Well, family, we have arrived at the final chapter of our deep dive into the Adam Coy trial. A journey that has taken us from a family's raw grief to the controversial testimony of a paid expert, $250 an hour witness, that is. Today, we will bear witness to the most anticipated moment of the entire trial, Adam Coy's own testimony. We will hear from the man himself, a convicted murderer who still believes his actions were justified. His words and his demeanor under intense questioning will reveal a mindset that is at the very heart of this tragedy. This moment will be crucial for our understanding, a chance to hear the truth from an officer who had life and death in his own hands. Following Coy, we will dissect the powerful and final clash of narratives in the closing arguments. The prosecution, armed with evidence and weight of Andre Hill's death, will deliver their final impassioned plea for justice. Their words will dismantle every weak justification and remind the jury of the human life that was lost. Then we will turn to the defense's closing, their last stand, a final, desperate attempt to create reasonable doubt and defend the indefensible. But before we step into the courtroom for the final act, we'll begin with the short clip to get everyone caught up on the most critical moments of this trial.
Criminal charge just for these types of situations, and it's called a violation of civil rights. And that's evolved over how many years in our judicial system, in our criminal justice system. So when you have a violation of civil rights, when a law enforcement comes into contact with a civilian, there's measurements federally, and there's procedures. Now you gave, you let the experts opine on the federal standard of within the national standards and things of that nature, and that was your choice. Other judges here in this county use the state where it's reasonable. But when you take that, Your Honor, the issue is that specifically tailored those procedures to a violation of civil rights. That's why they apply it. So you have a checklist, you have a guide, a roadmap of how to follow and whether it matches or not. So it makes logical sense. Just like, therefore, he must have had the intent to do a felony. If he didn't follow those, he must have had the intent to commit a felony for felony murder. And that's just wrong. That's inconsistent with logic. It's inconsistent with the federal system. It's inconsistent. And it's our fault as a justice system because we don't have any instructions on this. We don't have OJ on it. We haven't tested it. We haven't put it through the committees. We haven't put it through the steps that happen, Your Honor. I was disappointed today, this morning, when I found out that our county prosecutor was having a press conference outside the courtroom right after this. At first, I'm like, oh, why would you politicize this? Why? I mean, and more. Again, hopefully it's going to be for good, and hopefully it's going to be improved, and hopefully it's going to be improved and say, okay, hey, this is a wrong charge for these types of cases. Our system is imperfect. There are innocent people in prison. We know that. We know that from this DNA cases in Illinois, here in Ohio. We know that. Sometimes juries get it wrong. That's why we have an appellate process, Your Honor. Adam will appeal in this stuff. I've had him sign the notice of the timing, Your Honor. I've had him go through that. We will order the transcripts, and we will continue this in a respectful way.
They're charged with murder. Plan to ask the court for a lower bond. Adam Coy remains in jail tonight in connection with the death of Andre Hill. The video released today by the Franklin County Sheriff's Office shows Coy walking into the jail in handcuffs late Wednesday. It was after a grand jury indictment on murder, felonious assault, and dereliction of duty charges. At Friday's arraignment, a judge set a $3 million bond for Coy. He fatally shot Andre Hill in late December during a non-emergency call. Hill was unarmed. A hearing on the bond reconsideration now scheduled for tomorrow morning.
Okay, first with respect to case number 1607. We're going to arraign that case first. Okay, Mr. Pearson, it's my understanding that 21 CR 1607 is all out of the same incident. Is that correct?
Yes, Your Honor. This is an additional charge arising out of the same incident that occurred on December 22nd.
Two quick questions. For one, how is he out on bond after he killed somebody? And for two, why did they say $3 million, but he actually got out on $100,000 on a $1 million bond? And he got out.
Signature of the defendant as well. So the court will accept the plea of not guilty because of the fact that this matter is is part of the same incident as to 21 CR 451, the court will maintain the bond that is currently in 21 CR 451. It's $1 million appearance surety, $20,000 recognizance bond with reporting requirements. Stay away from the victim or anyone that is likely to testify in this matter. Surrender passport, no contact with law enforcement officers that are associated with this case, not to possess a weapon or firearm. Okay, do you have any questions, Mr. Coy, with respect to the conditions of your bond?
I do not, Your Honor.
More of the investigation by the Columbus Division of Police into the deadly police shooting of Andre Hill has been released. Tonight, we know key points about how now former officer Adam Coy's past played a role in his firing.
Well, Kerry, Police Chief Tom Quinlan's recommendation for termination was rooted in Adam Coy's failure to render aid, his failure to turn on his body camera, and of course his his use of deadly force. And Quinlan's own investigation led him to the determination that termination was in fact the only appropriate action. In those documents, Chief Quinlan said he was notified within minutes of the shooting and he responded to the scene on Oberlin Drive immediately. He reviewed the body camera footage and said the video raised many alarms about Officer Coy's actions in using deadly force, concluding that his use of force was not reasonable, that he did not use proper training techniques, and that his actions were not a rookie mistake, rather reckless and deliberate. We also learned about the history between Quinlan and Coy. Quinlan was once Coy's patrol lieutenant. He said during Coy's 19 years as a patrol officer, Coy has been counseled, trained, and mentored perhaps more than any other officer in the department. In 2008, Quinlan wrote, "If sustained improvements are not fully realized, a decision whether Officer Coy is salvageable must follow. Should the interventions described above not produce the desired results, a shift towards termination would be warranted, as Officer Coy's service to the Division of Police will have lost all future value." Quinlan said last week he could state unequivocally that Officer Coy had no future value to the Division of Police and should be terminated. Today, NBC4 spoke to Coy's attorney Mark Collins, who's representing him in the criminal investigation. Here is his response to that 2008 letter.
This is the ultimate clash between two realities: the reality of a system protecting its own and the reality of a life unjustly taken. How was the final verdict reached? The answer lies within these final arguments. Remember that all video and audio clips used are part of the public record and are used for the purpose of analysis and commentary. If this journey into the truth resonates with your spirit, please like, subscribe, tap in, share with a friend. And now let's get started with the testimony of Adam Coy. Stay vigilant, stay fresh, and stay blessed, family. Let's get it.
What up, no one? I see you. TSC in the building. Aaron adventuring. I
I'm
see
standing at the
you.
widest portion of the driveway right now.
Rock
and I'm
Solid
looking-
TV. Appreciate
That
you.
window leads into the living
Shit,
room.
About to pause. Rock Solid TV. No one. Aaron adventuring. Watch the rise. Chan My Black is Golden. Appreciate y'all. Let's get into it without any further ado. Appreciate y'all being the first ones here. Much love. Hit that like button. Hit that subscribe. Let's get it.
When he goes into his vehicle and rummages around, what are you thinking?
I was wondering, what is he retrieving from the vehicle?
Okay. When you saw him walking the first time up to the house, did you see anything in his hands?
No, sir.
Okay. When he was walking back from the house, did you see anything in his hands?
No, sir.
After the rummaging and he's in front of your car, do you say anything to him?
As he starts to pass back between our vehicles again and walk back towards the house, I verbally said to him, "What's going on?"
Why did you say that?
Because I wanted to know what was going on. Things weren't adding up.
What do you mean things weren't adding up, Adam?
The statement that he had given me that he was there to pick somebody up, the fact that they were getting ready to come out, coupled with the fact that he's pounded on the front door of a house that he's not even parked in front of. There was plenty of places for him to park. He could have just pulled right up in front of 1062. All these things are starting to add up to something that isn't making sense.
So the record's clear. So from where you parked in front of 1070, there was plenty of room in front of 1060 is what you're saying?
Yes.
Okay. Or
1062.
I'm sorry. Okay. And then when you asked him what's going on, was there a response?
Not verbally.
Okay. When there's no response, what goes through your mind?
Why isn't he responding to me? It seemed like he had said that he was there to pick somebody up, and now he's distancing, himself from me further.
Okay. What else do you observe?
I'm sorry, sir?
What else do you observe next?
He walks towards the house, 1062 Oberlin again, up the driveway. But as he's walking, he keeps looking back over his shoulder to see where I'm standing.
What does that mean to you based on your training and experience, Adam?
One of the things we look for is, they're called targeting glances. When somebody is looking at you, or I've even had them where I'm talking to them and they're staring at items on my belt, it makes you start to think, what is this person's intention?
The fact that he's looking back or targeting you, what does that do to you towards reasonable suspicion?
With the totality of everything that's going on at this point, I'm starting to gather more reasonable suspicion that there is a crime going on and he's not being truthful with me.
Okay. All right. So what's your intent? What are you going to do next?
At this point in time, I haven't moved. He's going up the driveway and I see that there's a vehicle coming down the roadway. So I look to my right and I see that it's Officer Detweiler and she's about to pull up with me.
I understand that, but at this point in time, when the person walks away from you, doesn't answer, are you going to find that person and investigate?
Yes, I need to know what's going on.
Okay. Officer Detweiler pulls up.
Yes, sir.
And so just for the record, that would be behind the flag, correct?
Yes, sir.
That way. Okay. More in front of 1062.
Correct.
Okay. When you look to see Officer Detweiler, can you now see the individual that was in the car?
No, he's gone from my line of sight. There was a pine tree there. When he went around the pine tree, I couldn't see him anymore.
Okay. What are you going to do next with regards to furthering your investigation?
We need to question the individual, find out what's going on, possibly try to make contact with people in the house.
Where were you going to head?
I'm sorry, sir?
In order to do that, were you heading to the front of the house, down the street, or behind the house?
Well, at first, before I even move, I turn to Officer Detweiler as she gets out. And at that point, I say, she asked me, what do we have? And I said, I'm not sure what's going on, but something's not right.
Okay. Had you conveyed to her that Tag didn't come back to this neighborhood?
No.
Okay. Had you conveyed,
Hey, real quick, Adventuring always coming through with the early facts. She said, allegedly, I guess allegedly, not a fact, his bond was reduced because he got diagnosed with cancer, which he did. That's how he got out, was using the whole cancer thing. So I believe that, but it's not the official transcript, so I can't confirm it 100%. So that makes sense of why they would reduce it, but that's still crazy though. Appreciate you. What up, Joni 4? I see you. Y'all drop some Blue Jays in the chat for Joni 4.
when you say something's not right, had you worked with Officer Detweiler before?
Many years, sir.
When, and I apologize, what did she say to you?
She had asked me when she first stepped out, she had said, is it code 4?
What's that mean?
That she's not needed, that she can just clear the run.
Okay, and what did you tell her?
That's when I told her something, I don't know what we got, but something's not adding up.
Okay, all right. What is your intent next, Adam?
To make contact with the individual that I originally had contact with and see where he went. I was going to go around the backside of the house.
Okay. Why the backside of the house?
He tried to make entry in the front half and didn't get in. I figured the next door available was probably in the backyard.
Okay, all right. And that's based on your experience?
Yes, sir.
Where do you start to go towards?
We walk up the driveway of 1062 Oberlin,
I apologize for interrupting, but when you say we, I have to ask you, who's we?
myself and Officer Detweiler.
And where is Officer Detweiler in relationship to you?
She's behind me and to my right.
Okay. And what path do you take at this point in time?
I had went to the left side of the driveway so that I could get a better view of the last place that I saw the individual at. And Officer Detweiler was offset from me to my rear and over on the right-hand side of the driveway.
Okay. Do you know if Officer Detweiler had her weapon out or not?
No, sir.
Did you have your weapon out at that point?
No, sir.
Okay. So to give the jury some perspective, so you're coming, if you're 1062, you're coming from the left of, facing, you're to the left of 1062.
Yes, sir.
Officer Detweiler's kind of coming straight up.
Yes, sir.
1062. When you go around or when you go step forward, what's the first thing you notice?
That the garage door is open and it's pitch black.
Why is that important to you?
again, the thefts and robberies, burglaries, and things that happen this time of year, and I didn't notice before, but now this garage door is open, and didn't know if they purposely left it open, if somebody had broken into it. I just knew it was open and dark.
Why is the dark important to you in your analysis?
Being that I don't know what's inside the garage, I then use my flashlight to shine in to see.
When you realize that the garage door is open and dark, are you still going to go to the back of the house, or where are you going to head next?
My intention at first was to go to the back of the house, but as I see the garage doors open, it changes my focus from the rear of the house to the garage door. And at approximately the same time, I see a light flicker in the back corner of the garage.
Okay. When you first observed the garage door open and dark, could you see anybody in there?
No, sir.
At this point, do you have a continuing duty to investigate?
Absolutely.
Go forward.
Yes, sir.
At what point do you see something in the garage?
Maybe 2 or 3 steps up the driveway, I see a flicker low to the ground in the back corner of the garage.
Okay. And if you're looking at the garage, where do you see that?
At the back right-hand side.
Okay. And you say you see the flicker low?
Yes, sir.
Okay. And what do you do at that point in time, Adam?
I have my flashlight out and I start shining my flashlight into that corner so I can light up what flicker I saw.
What do you observe?
Mr. Hill's crouched down in the back right-hand corner of the garage.
Okay. Crouch down. And why, when you say someone's crouched down, what does that mean to you in your investigation?
It seems weird with everything else that has occurred thus far in this run. Now, why is this person in the dark garage kneeled down in the back corner of a house that no one's answering?
Okay. And with
Knowing damn, so you just gonna get up here and lie? You just gonna get up here and lie, knowing damn well that ain't nowhere in the video, nowhere part of the stuff. You gonna try to add stuff to the statement now? That's insane. That is insane.
The truth is, you are a liar.
with garages I mean, sometimes people forget to close garage doors, correct?
Yes, sir.
Okay. So there was no light on that was tripped on or anything like that?
No, sir.
Pitch black?
Yes, sir.
All right. You see the person crouched down. What happens next?
I shine my flashlight on him and I say, something's not adding up here. Come out here, show yourself.
Okay. Something's not out here.
Something not adding up. Come out here, show yourself. My bad, I ain't gonna keep cutting it, but man, this is just already getting irritating. What up, Chad? My black is golden. Y'all show her some love. Drop her some witch emojis.
Come out here, show yourself. When you say show yourself, have you used that before as a police officer?
Yes, sir.
What do you mean by that?
Due to the fact that he was crouched in the corner, I was talking to his whole body. I wanted to see every bit of him.
Okay. Were you eventually able to see his whole body?
No, sir.
Okay. When you first saw him, which way was he facing?
He was facing towards the house and standing in the garage facing towards the house.
All right. So if you're the back of the garage, he would be facing towards the screen?
Yes, sir.
Okay. And what was your thought process at that point when you observed that fact?
What is he doing in there? Why is it dark? Why is he not responding to anyone inside the house?
You order him to show yourself what's going on. Come out here.
Yes, sir.
Okay. Do you have your weapon out?
No, sir.
Do you know where Officer Detweiler is?
Somewhere behind me.
Okay. What happens next, Adam?
Mr. Hill's walking towards me.
Okay. Does he immediately come out?
No, sir.
Does he respond to your question? What's going on?
Not at first, sir.
Did you hear anything from him?
No, sir.
He starts walking out, correct?
Yes, sir.
How does his body appear to you at that point in time?
He's, instead of walking directly towards me, he kind of walks towards the parked vehicle in there, and his body is turned to where I can't see his right side. I can just see his left side.
What does that tell you based on your training?
It's called blading. It's a stance that like a boxer would take if they're going to get into a fight.
Adam, Mr. Hill's coming towards you. Can you see his?
The bladed position. When else have we heard that before? What other trial that we recently covered, well, not trial, officer shooting, where they used that bladed position? The Ryan Hinton. They said, oh, he had a gun pointed in the bladed position.
His right side.
No, sir.
What do you see?
There was a cell phone in his left hand.
How does he have the cell phone?
Screen pointed outwards, kind of held up, pointed at shoulder height.
When you observed that, what went through your mind?
That it was a distraction. He was trying to get me to look at the phone.
Okay. Could you see his right side at that point in time?
Not yet.
So when you say sucked up to the car, if this is the car, the back of the car, there's a part here that's at the end of the garage, right?
Yes, sir.
Okay. So when you say as he approached you, he's sideways like this.
Yes, sir.
At some point, does he turn towards you?
Right at the very corner of the car.
Okay. And at the corner of the car, when he turns towards you, what do you see?
Silver revolver in his right hand.
Where was that silver revolver coming up in his right hand?
From behind his leg, and it was coming up at me.
Okay. And when you saw that, what did you think was going to happen, Adam?
I thought I was going to die.
What did you do in response to that, Adam?
I drew my gun. I yelled, gun, gun, and I fired 4 shots.
Why did you fire 4 shots?
That's what stopped it.
Okay. Did you fire any shots before when he was sideways?
No, sir.
Did you fire any shots when he was going to the garage or anything like that?
No, sir.
When you saw him come to the edge of the car, what did you see in his right hand?
A silver revolver.
Okay. Why a silver revolver, Adam? What would describe that for ladies and gentlemen of the jury?
It's a revolver is thinner in the front and thicker in the back.
Okay. What happens next, Adam? Did you turn your body-worn camera on?
Immediately.
Okay. What happens next?
I keep my weapon trained on Mr. Hill. He's down, but I can't see the gun anymore. I can't see his hands. Officer Detweiler says that should I approach, and I tell her to stay back.
Why?
I still couldn't see his hands. I wanted to see where that gun was.
Okay. What, is that based on training?
Yes, sir.
Can someone be on the ground and not be an immediate threat, but be a potential threat?
Yes, sir.
Okay. At that situation, did Officer Detweiler listen to you?
She did.
What did the two of you do next?
Gave more commands for hands to come out and slowly move forward.
What happened, Adam?
I got up to a point where I was standing next to Mr. Hill, and I rolled him back. And as I rolled him back, I looked to my left, and I started looking for where the gun was. And I seen the pile of keys sitting there. And I said, fuck.
Why, Adam?
I knew at that point that I made a mistake.
Okay. Had you seen keys in his right hand, would you have
Of keys sitting there. And I said, fuck.
Why, Adam?
I knew at that point that I made a mistake. And I said, fuck.
Why, Adam?
I knew at that point that I made a mistake.
Okay. Had you seen keys in his right hand, would you have fired your weapon?
No, sir, I would not have.
Had you seen a cigarette pack in his right hand, would you fire the weapon?
No, sir, I would not have.
Did you believe that he had a silver revolver in his hand?
I did.
Okay. How did that make you feel, Adam, when you realized that you were mistaken?
I was horrified. It was the worst night of my life.
What did you do at that point, Adam?
I went in shock. I started dry heaving. I couldn't control myself. I couldn't think straight.
Did you tell anybody what you were believing in your mind as to the reasonable suspicion about what might be going on?
No, I did not.
Why not, Adam?
I'm not quite sure. Everything just went as a blur to me, and I knew I had just been involved in an officer-involved shooting, and that I was supposed to remove myself from the situation. I'm no longer supposed to be part of this investigation.
Did you ask to call a medic?
I did.
Who did you ask that to?
Officer Detweiler.
Did you ask for officer support?
I did.
Why?
Because I had just been involved in a critical incident. I needed officer support there.
Okay. Do you remember wandering around the scene?
Not really. Okay. I remember just being dazed. I remember wandering around the driveway a little bit.
Is there any doubt in your mind that you saw something silver in Andre Hill's hand coming towards you?
No, sir, no doubt.
When you saw that, what did you believe was going to happen?
Thought I was going to die.
Why did you fire your weapon at that point?
Because I saw an imminent threat, and I didn't want to get shot right before Christmas.
Would you ever want to get shot after Christmas, Adam?
No, sir.
Why you throw in, I didn't want to get shot before Christmas? Oh, I just was trying to get a bonus. They said if I kill a nigga, I get paid if I get away with. My bad.
Might have a
before
moment.
Christmas.
Because I saw an imminent threat, and I didn't want to get shot right before Christmas.
Would you ever want to get shot after Christmas, Adam?
No, sir.
May I have a moment, Your Honor?
You may.
Adam, that's all the questions I have for you. Thank you very much.
Thank you, Mr. Collins. Cross-examination.
Take a 5-minute break, Your Honor.
Well, we never take 5 minutes, but let's go ahead and take 10.
Thank you.
All right, ladies and gentlemen. Good afternoon.
He had them tears on point, huh? He had them ready to go. I mean, he crying, but he ain't crying because he killed him. He never said he felt sorry about killing him. He crying because he know he messed up and he about to be in jail for the rest of his life. That's why he crying. Because he see they ain't got his back like they usually have everybody back. But anyway, let's keep it rolling. Let's get to the cross-examination. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. Let's go.
Afternoon, Mr. Coy.
Good afternoon, sir.
As you know, my name is Anthony Pearson. I'm going to be asking you some questions today, okay?
Yes, sir.
And most of my questions will be yes or no. So if you can answer them in that manner where possible, please do so, okay?
Yes, sir.
Also, if you don't understand my question or it's confusing or anything like that, please ask me to rephrase, or if I mumble and you can't actually hear the words that I'm asking, please let me know and I'll make sure you can hear them, okay?
Will do, sir.
All right, thank you, thank you. Starting off, Mr. Coy, you do admit that some of your tactics were off that night, correct?
I don't understand the question, sir.
Okay. Do you think your tactics were perfect that night?
Tactics meaning what, sir?
Everything that you did leading up from the time that you made first contact with Mr. Hill until after you left the scene.
I think my mistake, sir, was seeing keys as a revolver.
All right. Well, you acknowledge that he did not have a revolver, right?
Yes, sir.
He didn't have any weapon at all, correct?
Yes, sir.
All right. Outside of that, mistaking the keys for a deadly weapon, you would agree that you made other mistakes that night too, correct?
No, sir.
Okay. You provided a written statement regarding the events in question, didn't you?
Yes, sir.
Okay. You also had an interview with the Bureau of Criminal Investigation after that, correct?
Yes, sir.
All right. So I believe the record that I have is that you spoke with agents on or about January 20th, 2021. Is that correct?
If that's what it says, sir.
It was about a month after this incident happened on Oberlin?
Approximately.
And your written statement was submitted to them about a week before that. Is that right?
Again, sir, I'm not sure of the timeline.
Okay. You wouldn't have any reason to disagree with that, correct?
I don't know the timeline, sir.
Okay. Let's talk about this incident. So you stated you were having your lunch when you got the call to dispatch to 1062 Oberlin?
Yes, sir.
So about how far were you into your lunch break?
I don't take a break, sir. I just eat my lunch while I'm still active and ready for service.
Okay. About how long had you...
He said, I don't take a break. I eat my donuts and coffee while I'm still pursuing.
gotten into your lunch
pursuing.
before you were dispatched to this Oberlin address?
To be honest, sir, I don't even remember what I had, so I don't know.
Okay. So you're dispatched to this Oberlin address. You go there. Is this a lights and sirens call?
No, sir.
All right. And it was a noise complaint. Is that right?
No, sir.
You took it as a suspicious vehicle?
It came in as a 16, which is a disturbance, but it read like a 48A, which is a suspicious vehicle, suspicious person.
All right. And when you arrive there, you see a vehicle parked in front of the house where 911 was called from. Is that right?
Yes, sir.
And you get out of your cruiser at that time?
I did, sir.
And you approach that vehicle?
Yes, sir.
And Mr. Ronker.
All them tears didn't dried up, huh, no one?
The 911 caller directed you toward where the silver SUV was, correct?
Yes, he said it was further down the road, sir.
Right. And you get back into your vehicle, move your vehicle closer to where that silver SUV was, right?
Yes, sir.
Okay. And what did you do as soon as you parked your vehicle, I'm sorry?
What did I do, sir?
Yes, what did you do?
I exited the vehicle.
And what was the purpose of exiting your vehicle?
To make contact with the person in the running vehicle.
Okay. And you stated on direct examination that Mr. Hill showed you text messages, right? He showed you a phone.
It shows me a text bubbles. That's all I could really see, sir.
That's all you could really see?
I couldn't read the text.
Okay. In your written statement, you wrote, he showed me his phone screen that had a text message on it that said, I'll be right out, or something to that effect.
He said, it told me what it was saying on the text message.
Oh, because so now your testimony is he told you what it said?
While he's showing me the phone, he told me what the text message was supposed to say. I didn't actually see the text message itself.
Okay. Well, in your statement, it reads, he showed me his phone screen that had a text message on it that said, I'll be right out, or something to that effect.
In the same fashion that I would tell you this is a water bottle, sir, he was showing me his phone, telling me about the text at the same time. I never read them myself.
Okay, but you didn't say that in your written statement to the investigators, did you?
It depends how you interpret that
He really up here trolling, huh? Why though? Why would you even do that?
statement, sir.
Okay. Well, let's go to your statement when you were interviewed by the Bureau of Criminal Investigation on January 20th, 2021. There was a question. Did you see the text messages? And your response, he held it up, and I seen something on there that said, be out in a sec, or in a sec. Do you recall saying that?
No, sir.
Okay. If I played this for you, would that refresh your recollection as to whether you actually said it or not?
I would hear it, sir.
Okay.
The truth
All
is that you are a
May I
liar.
play this for the witness?
Yes. All right. We're going to try to take 5, ladies and gentlemen. Don't leave the jury room. Okay? Again, remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury.
Remember the admonition, ad hominems, and all the extra stuff. Like, get out of here with that, man. You playing games. That's crazy. You playing games. You playing games. Appreciate y'all being here. We're gonna keep it rolling. He up here straight trolling on the stand though. Crying, then all of a sudden he done switched up his whole energy. Let's see, Chan said, this is too much for me. Y'all younger folks are good. I have to
Mr. Pearson, just so that
grin
the
and
record
bear
is
too
clear,
much.
what
I
is it
see
that
every
you've
day.
provided to the witness?
I provided the
No
witness
soul, no
transcript of the conversation or the interview that the witness had with BCI on January 20th, 2021.
No consciousness, just empty liars.
All right. Thank you.
Okay. Are we good?
Yes, sir.
Okay. Does that refresh your recollection?
Yes, Your Honor. It says, okay.
Just yes or no at this point in time?
Yes, Your Honor.
Okay, all right, very good. Okay, let's bring the jurors back in.
The truth is that you are a liar. I'm the gatekeeper.
You drove my wheels.
Lady Justice is blind. Everybody can hear.
You did say.
All right, Mr. Pearson, you may inquire.
Thank you. So, Mr. Coy, you did say he held it up, and I seen something on that said, be out in a sec, be out or in a sec, correct? You said
Says
that.
something like that, yes, sir.
I seen something on there that said, correct?
The full sentence is something like that, sir. I was obviously didn't know specifically at that point either.
Okay. But there was no indication, no words by you that you're going off of what you were told. In both your written statement and in the statement you made to BCI, you're referring to something you saw with your eyes, aren't you?
That I saw a text screen, sir.
But it's your contention today that you didn't read that screen. This is coming from what someone said in the vehicle.
I said, when Mr. Hill said to me that she'll be out in a minute and holding up the text message to show me, I seen that there was text bubbles. I can barely read this without tipping my glasses up, sir. There's no way I read a cell phone.
Okay. So it's your contention, Mr. Coy, that on December 22nd, 2020, you had something wrong with your vision?
I've worn contacts and glasses for years, sir. My vision has gotten worse since the cancer.
So it's your contention that you had something wrong with your vision on that day?
Objection, Your Honor, that's not his answer.
Overruled.
Lady Justice is blind. Everybody can get it.
Again, I wear contacts, sir.
So you said in front of this jury that you weren't able to see those text bubbles, right? Is that what you said?
I could see there were text bubbles. I couldn't read the text.
You could not read the text. All right. Let's back up just a second just a moment in this exchange that you had with Mr. Hill. You said as you approached the vehicle, what did he do?
First, he rolled down the driver's side window. He leaned with his left arm towards his right knee, used his right arm, held the cell phone out and back towards me.
And do you kind of approach kind of close up to the vehicle as you approach a vehicle?
Not extremely close, not touching, but close, sir.
Okay. Is that for officer safety reasons?
Yes, sir.
And you also don't go directly beside the driver, is that correct? Or a little bit back for officer safety reasons as well?
Yes, sir.
So as you're having this conversation with Mr. Hill, you're slightly behind him, right?
Yes, sir.
Okay. So in order for him to talk to you, he's going to have to turn his body to at least make eye contact with you or look at you, correct?
I would believe so, sir.
And you stated that he took his left hand and he put it on his right knee?
Covering up his lap, sir.
Covering up his lap?
Yes, sir.
Okay. You sure about that?
Yes, sir.
Okay. Why don't you take a look at that statement that you have in front of you? Go back one page prior. And you said to the BCI investigator, so the vehicle, the window rolls down. As I approach and start to shine my light, Mr. Hill puts his left arm on the window here, his left arm onto the seal of the window. With his right hand he leans back toward me and show me the display of his cell phone.
Yes, sir.
That's different than what you're saying today, isn't it?
No, sir.
Oh, which one was it? Did he have his left hand on the window or the left hand on his right knee?
If this is the windowsill, his left arm is on the windowsill, his left hand is on his right knee. It's both, sir.
Your left hand is on your left knee. You mean to tell me that he reached over all the way to his right knee with his hand on the windowsill?
With his elbow. He had his elbow on the window, rolled down the window, put his elbow here, was covering up his lap, putting his hand this direction, and this one back here. Make it an X, sir. It's the same thing I say in the statement.
Can you point me to the part in your statement, again, this is a transcript, where you make any reference to his hand being on his knee? Oh, wait.
Say again, sir.
Point me to the part of your statement that you gave to BCI where you say Mr. Hill put his hand on his right knee.
It just says his left arm is on the seal of the window, sir.
Okay. So that's not what you said today, is it?
Not exactly, sir.
Okay. You said that you found it odd that he addressed you before you addressed him, correct?
Yes, sir.
What is odd about that, Mr. Coy?
Normally, people don't even roll down their windows till I get up to the vehicle and actually knock on it. That's just the normal way that traffic stops occur. So the fact that he rolled down the window and was already trying to tell me something before I ever even approached him seemed odd to me.
Well, this wasn't a traffic stop, was it?
No, sir, it was not.
Okay. This was a consensual encounter, correct?
Yes, sir.
At any point in time, well, up until this point in time, he could have just drove away, couldn't he?
Yes, sir.
So he addressed you, talked to you when he didn't.
Look, see how easily he said up until this time, he could have just drove away. He said, yes, sir. That's a fact. He could have legally, but if he would have did that, then he would have been on a high-speed chase. So I don't even know why you said yes, sir, because the answer was hell no. Because if he would have pulled off, y'all would have chased him down.
Didn't have to, correct?
Yes, sir.
He was polite to you, wasn't he?
Yes, sir.
He didn't use any foul language, did he?
No, sir.
And he told you what he was there for, didn't he?
He said that he was there to pick someone up.
But yet and still you found that behavior odd.
I found the entire incident to be odd, sir.
Okay. At what point in time did you start to think that this encounter is odd?
After I'd made contact with Mr. Hill, with the predetermined at that point, and saying he was waiting on somebody, having been there for almost 3 hours.
Okay. And what did you do after that, Mr. Coy?
I told Mr. Hill to have a good evening and return to my vehicle.
Then, hold on. So you told him have a good evening and return back to your vehicle. So what is you still doing there? How do you end up coming back and shooting him after you told this dude have a good evening and go back to your vehicle? Don't that mean the investigation over? Or you was sneaking? You just told him that for play. You could go. No, I'm just playing. You can't go. The fuck?
This encounter wasn't odd enough to at least to ask him his name?
Not at this point, sir.
But you recognize you could have done that, right?
I recognize, yes, I could have asked him his name.
Okay. Oftentimes in your years of policing, your 19 years of policing at this point, you've often asked people for their names, haven't you?
When it's necessary, sir.
You've asked them for their IDs if they have them, correct?
Yes, sir.
Mr. Hill was in a vehicle at that time.
Yes, sir.
Do you think it would have been improper for you to ask him for his name?
Improper?
Yes.
Not improper, sir.
Okay. And you ran the license plate to the vehicle, correct?
A little bit later.
How long? How much later?
Approximately a couple minutes, sir.
What was Mr. Hill's behavior at the time that you're having this conversation with him?
He seemed wide-eyed and jittery, very dismissive. He seemed like he just wanted me to leave.
Okay. Wanted you to leave after he volunteered information to you?
In the manner that he was showing me the information and telling me that he was waiting for somebody.
Okay. Did he tell you to leave?
No, sir.
Did he ask you, why are you here?
No, sir.
And you go and you run the plate, and what were the results of the plate run?
It came back not stolen, but it didn't belong on the Overland Drive.
What do you mean it didn't belong on Overland Drive? Does a vehicle, are they limited to where they can travel?
Normally at that time of night, sir, the vehicles that are parked out front of houses and in driveways usually come back to the same house.
Okay. Certainly not always.
Not always.
So Mr. Hill was in a vehicle that didn't belong there because it was not registered to them.
So is it not crazy that he is still trying to make it like it's this dude's fault and trying to put the blame on him? Like it's his fault and everything he was doing was wrong, and that's the reason why he ended up getting shot, because he shouldn't have been over there at his family house and everything was so suspicious. He was kneeling down. Like, how many times you gonna keep on bringing in these lies or this extra stuff? What do that got to do with you killing this man for no reason? And then you gonna just keep on making up shit? That's crazy.
That address.
I didn't say that it didn't belong there. I said that the Oberlin Drive wasn't the address that was on the license plate. Therefore, it normally wouldn't be there.
Okay. My apologies, Mr. Coy. I'm just using your vernacular. Overruled. So you have this conversation, I'm sorry, let me back up. Did you talk about anything else with Mr. Hill?
No, sir, I did not.
Where was the caller at that point in time? Did the caller go back into the house or did he remain outside?
At that point in time, I'm sitting in the vehicle running the tag. I'm not sure where the caller was, but when I stepped out of the vehicle to stand next to my vehicle, I seen the caller was still in his yard.
Is it your understanding that the 911 caller watched a lot of this interaction that you had with Mr. Hill outside?
Objection, Your Honor.
I'll rephrase.
Well, I mean, if he knows.
Thank you.
Could you repeat the question?
Yes. Was Mr. Hill outside? I'm sorry, was the 911 caller outside at that time that you could tell?
Again, when I stepped out of the vehicle was the first time I looked back down and seen the caller was still there.
Okay. Did you ever see him go back into his house or did he remain there?
No, I did not.
And at one point in time, he came down to tell you something, correct?
He started that direction.
Yes.
Right before you shot him down.
Do you recall where that vehicle came back, like the name of the owner of that vehicle?
No, sir, I did not.
So if you have someone who was 1:40 in the morning, according to you, he's jittery and wide-eyed, and you decide to not ask him for his name, that's what you did?
At the time, he gave me an explanation for him to be there. It seemed reasonable up to that point.
Seemed reasonable up until that point, right? Is that what you stated?
Yes, sir.
Okay, there's a lot of reasons why people would be outside at this time of night, correct?
I would say so.
Yeah, there are legitimate reasons why someone would be outside at that time, correct?
Yes, sir.
And you and your partner both thought that it could be that he was warming up the car to stay warm, right?
That's what I thought. I'm not sure what Officer Detweiler thought.
So at this point, Mr. Hill wasn't operating a vehicle because it was parked, correct?
Vehicle was running, sir. Physical control.
So the vehicle was running, but it wasn't moving. Is that right?
Correct.
You hadn't seen him do anything illegal or wrong?
Not at that point.
And instead of him giving you problems or telling you to go mind your own business, he told you the reason why he was there, correct?
Yes.
If he had told you to go pound salt or go somewhere else or mind your own business, there would have been nothing legally you could have done about that, correct?
Yes, sir.
Because this was a public street, correct?
Yes, it was.
And he had every legal right to be there at that time?
Yes, sir.
And you decided that it wasn't necessary to ask him any further questions. You went back to your vehicle, and was at that time, a little bit of time later, you ran the plates, correct?
Yes, sir.
And then at some point in time, Mr. Hill goes out and, according to you, bangs on the door to that residence. Is that right?
That's correct, sir.
And you said he banged on that door not once, but twice.
Yes, sir.
And no one came out.
No, sir.
You later saw that there were people in that residence, right?
I did not, sir.
You didn't notice the woman come out after the shooting from the residence?
Not until body camera footage later on, sir.
And if you were so concerned about something happening at the residence, you could have gone up and knocked on the door yourself, couldn't you?
We hadn't gotten that far, sir.
So are you saying that would have been an improper thing to do?
That's not what I said, sir.
I know, but that is the question I'm asking. Would that have not been an improper thing to do?
In the timeline that we were involved in, sir, it wasn't that step that we were at.
So you're sitting in the car, and Mr. Hill bangs on the door, and then he comes back to the vehicle?
I was standing outside my car, sir.
Okay, you're standing outside your car with the door open?
Yes, sir.
Because, why are you doing that again?
That's the way I do it every time for officer safety, sir.
Okay. So you had safety in your mind, you were concerned?
Always.
But not enough to ask him for his name?
Objection, Your Honor. Asked and answered.
Sustain.
So you were concerned for your safety?
Yes, sir.
Okay. If you had asked Mr. Hill for his name or his license, and you relate that to dispatch, what type of information could you have gotten back?
Okay. He can answer that question. Overruled.
Thank you, Your Honor.
Driving history and address, driver's license number, date of birth, things of that nature, sir.
Would you have gotten back information as to whether he could have been a dangerous criminal if he were in that system like that?
Possibly.
You could have gotten back, if he had any, warrants?
Yes, sir.
You could have gotten back information as...
So real quick, y'all was talking about in the chat how everything he was saying was pretty much bad. He was saying like you can't. Okay, here you go. Johnny Ford said so. You can't sit in your car. You can't be someplace other than your own address that you that's on your registration. You can't be waiting on people. That's crazy. You can't do nothing. You can't do nothing. But that's BS. Like they use all that against you, but ain't none of that really they can use. Cause really, you can act like this in front of police. Not saying I'm advertising it, but just to show you an example of how you can really act in front of police, and they can't do nothing. Technically, but they do though.
Cold bitch, you a bitch, you a bitch. Why the fuck y'all fucking with these kids, man? Don't look for who y'all supposed to be looking for. You bitch ass nigga. Cold bitch. You definitely a bitch. You know you a bitch. All y'all say, man, fuck you, nigga. Don't touch me no more, bitch. I ain't touch your bitch ass. Fuck you, nigga. I'm gonna spit in your face and touch me again. Fuck you. Fuck this number. Don't touch me no more, you bitch ass nigga. Don't touch me, I'm gonna spit in your face, bitch. Fuck y'all. Yeah, fuck 12, nigga. Y'all know about me, you bitch ass nigga. I will spit in your face, bitch. Fuck you, all y'all. Fuck you talk about, bitch. Fuck 12, nigga. And I'm gonna put my own dicks. You a cold bitch, you a bitch, you a bitch. Why the fuck y'all fuck with these kids, man? Don't look for who y'all supposed to be looking for. You bitch ass.
So not saying I promote that, but I'm saying if that's how you want to talk to them, you have the right to talk to them like that. They are not supposed to shoot you and all this other shit and arrest you and be all offended. Get up out of here. What are you all in your feelings and emotions for? This has nothing to do with your feelings and emotions. Do your job.
As to whether he was even a licensed driver or not, couldn't you have?
Yes, sir.
And after he comes back to his vehicle, as you stated, he rummages around in the front seat area?
Yes, sir.
And then goes where? Where does he go?
In between our vehicles and back up towards the house again.
Okay. Is it at that point that you say something to him?
Yes, sir.
Okay. What did you say to him again?
What's going on?
And he didn't respond to you?
Not verbally, sir.
Was your car running at that time?
Yes, sir.
You've been a range officer for the Army as well as for CPD, is that right?
Yes, sir.
Fired a lot of shots, huh? Fired a lot of shots?
Yes, sir.
And you've actually put your employer on notice, the Columbus Police Department, that you had hearing issues at some point in time, is that correct?
After this incident, sir, yes. I wear hearing aids now.
And when you told Mr. Hill to talk to you, was your vehicle running?
Yes, sir.
But you said he didn't say anything to you?
That's correct.
Is it impossible that he said something in response, but you just didn't hear him?
No, sir. I was looking right at him.
The individuals at the house, Mr. Ronker and the neighbor, is it possible that they were saying things to you and you didn't hear them?
Who was that again, sir?
Mr. Ronker and the resident at 1062.
Ass nigga, hoe bitch. You definitely a bitch. You know you a bitch. All y'all some man, fuck you, nigga.
So you didn't hear any of that, and you didn't hear Mr. Hill make any response statement to you, and he just went up and kind of disappeared?
Yes, sir.
And you say that's at the time that Amy Detweiler arrived?
Approximately.
And you have a short conversation with her, right?
Yes, sir.
And you simply say something to the effect of, it's weird.
I believe I said something to, she asked me, what do we have? I said, I don't know, but something's not right.
Something's
Don't
not
touch
right.
me no more, bitch. I ain't touch your bitch ass. Fuck you, nigga. I'm gonna spit in your face and touch me again. Fuck you. Fuck this numbers. Don't touch me no more, you bitch ass nigga. Don't touch me. I'm gonna spit in your face, bitch. Fuck
So
y'all.
is it at that time that all of these things are kind of going off in your mind, that something terrible could be happening with respect to Mr. Hill and this house at 1062 Oberlin?
Within approximately a few seconds after that, as we start up the driveway, sir.
And as you're approaching the driveway, you don't give any other information to her, do you?
No, sir. We've worked together for years.
But saying something's not right could mean a lot of things, couldn't it?
My demeanor and body language gave Detweiler plenty of notice about what was going on, sir.
But you didn't have your gun out, did you?
No, sir.
No. No, he's sleeping.
So if Officer Detweiler stated that, as she did, that she believes you had your gun out, she's mistaken.
Yes, sir.
So let me get this straight. You're going into a garage that is dark, correct?
I didn't know that I was going to go in the garage at that point, sir.
You were approaching a garage that was dark, correct?
Correct.
With an individual who, according to you, ignored your commands, right? And you think that person is in the garage, right?
Not at first.
Okay. But you continue to approach it?
I continued up the driveway until I saw the flash of light in the garage, sir.
Okay. And at that point in time, you got the idea that he was in the garage?
Yes, sir.
And you continue to approach it?
Yes, sir.
Is that right? And you still don't have your gun out?
No, sir.
Let's talk about your approach for a second. Your Honor, permission to publish. I already admitted exhibits onto the Elmo.
What's the exhibit number?
We'll start with State's Exhibit I.
You may publish.
Thank you. Whoa.
I don't know what that means. Oh,
No.
All right, Mr. Coy, I'm displaying what's been marked as State's Exhibit I. Does this look familiar to you?
Yes, sir. I've seen it in the courtroom.
Yes. Right. So this is your vehicle here,
Yes, sir.
and this is Mr. Hill's vehicle? Wow.
Yes, sir.
Doesn't like this here. That's Mr. Hill's vehicle.
It's a glitch in
Yes,
the
sir.
matrix.
Can you, I believe there's a laser pointer up there. Can you show the ladies and gentlemen of the jury your path of travel?
From right here, I travel back this direction and over towards this driveway.
Do you go in front of this tree, or do you go around this tree this way?
In front of the tree, this way.
And you walk up the driveway?
Yes, sir.
And where do you see Mr. Hill? You said you saw a glimmer of light in the garage.
You can't see the inside of the garage of where you'd be at, sir. It would be more up here.
Okay. Going to hand you another, or show you another photograph. We'll go State's Exhibit A48. Are you able to show from this photograph?
Back over here, sir.
Okay. He was back over there crouched down?
Yes, sir.
And what did you say or do as you saw him and he was crouched down?
Before I said anything, he stood up, and then as I shined my light on him, I said, something's not right here, come out, show yourself.
Okay. And what did he do in response to your words?
At first, he stood there.
Okay. And then what?
Began to move towards me.
So did you ever figure out what wasn't right? You keep saying something wasn't right, something wasn't right. So what wasn't right? Did you figure that part out?
In what manner was he walking toward you?
Instead of coming straight out of the garage, it was kind of at an angle.
Okay. And then what happened next?
His body was bladed as he gets to the back of the car. And as he comes out the side of the car, I see a silver revolver in his hand.
Okay. So let's talk about this for a bit. You said he pauses for a second before complying with your orders?
Yes, sir.
And you said, I think you told Mr. Collins that he was kind of sucking up to the side of the car?
Yes, walking at an angle.
Okay. You acknowledged that there wasn't a tremendous amount of room between the vehicle and the house, correct?
Yes, sir.
And you were asked a question during your interview with BCI. You were asked what kind of pace is he walking at, and your response is, he's not running, he's not slow meandering to get there, but there is a quickened pace. Is that accurate?
Yes, sir.
And then there was a question. He started to come out when you verbally reached out to him, right? And your answer was yes. He was in the far back corner, and when I said something not adding up, come out here, show yourself, and he had turned and started to come out of the garage. That's right, isn't it?
Yes, sir.
And there's another question. Okay, so when you shouted, show yourself, he turned and started walking out. Would you say that he was obeying your commands? So I'm asking you this question now, Mr. Coy. Was he obeying your commands?
Partially, sir.
Partially. You told a man to come out, and he's coming out. Did you tell him to do anything else?
Show yourself.
And he was showing himself by coming out, wasn't he?
Only part of himself, sir.
Well, he was behind a Nissan Altima. What could he do more to show himself besides walking to you?
Not hide his right hand behind his leg.
So you're saying that he was hiding his right hand behind his leg?
He walked several steps. Why normal people walk with swinging the arms. He was walking with his right hand staying behind his leg.
Okay. At that point, you were concerned where his hands were?
Yes, sir.
But nowhere in this encounter did you say, show me your hands, did you?
It happened too fast, sir.
Nowhere in this encounter did you say, show me your hands?
I said, show yourself, sir.
When asked the question of, when you shouted, show yourself, he turned and started walking out, would you say he's obeying your commands right there? Your response was, he is. He is responding to my commands. But in a normal reaction from my training and the thousands of times I've had somebody when I give that loud authoritative voice, the response normally is to like, hey, you got it. What's going on? I didn't. He was responding to me there, but he wasn't responding in a manner that was submissive. Do you remember saying that to the agents?
Yes,
So would Mr. Hill still be alive if he was submissive to you?
Sustained.
So you contend that he was not responding in a manner that was submissive, right?
Yes, sir.
You said he sucked up towards the vehicle. Everything said to me while he was responding to me, he was not being compliant with me. You remember saying that?
Yes, sir.
But you would agree with me, Mr. Coy, that this man was doing everything you asked him to do, wasn't he?
No, sir.
Your Honor, asked and answered.
No. Overruled.
What's your answer, Mr. Coy?
No, sir.
I'm going to back up a bit.
The truth is that you are a liar.
As you're walking there up the garage and throughout this entire interaction, you had a mic on your chest, correct?
On my shoulder, sir.
On your shoulder. That communicates with whom?
Everyone.
And you would agree with me that it is your duty and responsibility to communicate important things to other police officers, isn't that right?
When it's time, sir.
Just to be clear, you never saw Mr. Hill with a weapon.
I thought what I saw to be a weapon, sir.
But you never saw Mr. Hill with a weapon, did you?
Again, Your Honor, asked and answered.
No. Overruled.
You never saw Mr. Hill with a weapon, did you?
No, sir.
You fired 4 shots at him, correct?
Yes, sir.
You were aiming center mass.
Yes, sir.
And you stated that you were attempting to mass.
Yes, sir.
And you stated that you were attempting to stop the threat, right?
Yes, sir.
And you were attempting to do that by shooting him, correct?
As I was trained, sir.
After the shooting, you tell your partner, Amy Detweiler, to get a medic,
Yes.
get officer support,
Yes, sir.
and then you exit the scene, correct?
I just kind of wandered.
And at some point in time, Officer Barsardi came up to you, correct?
Yes, sir.
And he was trying to, I guess, talk to you and provide you comfort, right?
He was trying to get me to leave.
And you stated to Officer Barsardi, I gotta find what I missed. Remember saying that?
Yes, sir.
Do you remember asking for a bottle of water?
Yes, sir.
And you were coughing, correct?
Yes, sir.
Do you have asthma?
No, sir.
Mr. Coy, would it be safe to say that after the shooting, you really stopped doing your job as a police officer, is that right?
I'm required to remove myself from the situation, per our policies.
You didn't let officers know about your thoughts about things that could have been happening in the house, correct?
I went into shock, sir.
So you didn't let any of the officers know that, correct?
Speak to anyone, sir.
All right. So no point in time did you call for backup?
I did not, sir.
Mr. Coy,
Yeah,
isn't it
fuck
true
12,
that
nigga. Y'all know about me, you bitch ass nigga.
you really never formulated an opinion that something serious was happening in that house, did you?
I'm sorry, sir.
You never formulated an opinion as to that there was something serious happening in that house, did you?
As we were walking up the driveway, I began to think that this could be a home invasion or a burglary. I just a couple months earlier, had a home invasion where I walked in on a ski mask person with a gun and had three girls downstairs, one girl upstairs, duct tape. It was fresh in my mind.
Mr. Coy, so fresh that you never pulled your weapon out, did you?
Not till I saw a threat, sir.
So much of a threat that you saw that the weapon.
It was fresh in my mind.
Mr. Coy, so fresh that you never pulled your weapon out, did you?
Not till I saw a threat, sir.
So much of a threat that you saw that this incident was so powerful that you never even told anyone about it, correct?
No, sir.
You didn't radio dispatch, did you?
I told Officer Detweiler too, sir.
And the fact was that you had shot an unarmed man who didn't have a weapon, and then you just came up with this story later to cover yourself, correct?
No, sir.
And the first time that you let any anyone know that you thought a burglary was happening is when you wrote that statement about a month after this happened.
No, sir.
Thank you, Your Honor. I have no further questions. Statement about a month after this happened.
No, sir.
But you just lied. Stop it. Stop it.
He is a professional liar. See, the thing is that as cops, they allowed to lie to suspects, so they think they can lie to everybody. And then they get on the stand, and you know that lying don't work so well on the stand, buddy. We can see all that. We can see all that. That's crazy. Let's keep it on rolling. Y'all hit that like, hit that subscribe.
Well, isn't this a nice surprise?
A25. The right side of the garage door. I'm looking into the garage again.
On the pavement of the garage, do you see an object underneath the white car?
The keys, yes, right here.
A26.
I'm actually inside the garage now. I would be walking towards that, the wooden door that I pointed out earlier right there.
A27.
Now I'm standing at the wooden door looking west. Still inside the garage.
A28.
At the wooden door again, looking out towards the driveway for some ballistic events, which are bullet strikes in the wall.
Okay.
So I photographed it.
You call them ballistic events?
Yes.
Okay. A37.
This is just where I thought the ballistic events were with the ladder moved out of the way.
Okay. A38.
This is where I used an L scale sticker and identified them as BE 1.0 through BE 4.0.
And BE stands for?
Ballistic event.
A39.
A close-up of the stickers and the holes.
A40.
Close-up of BE 1.0.
A41.
Another close-up of BE 1.0.
A42.
Close-up of BE 2.0 and BE 3.0.
And A46.
A close-up of BE 4.0.
And before we move on, can you just explain when you have these possible ballistic events, what do you do to try to get some information, additional information about whether or not they are in fact a ballistic event?
Because of the uncertainty of if they were bullet strikes or ballistic events, I used dithium oxide, which is a chemical that is used to test the presence of copper. What we do is we have bench coat paper, which is, there's a shiny side and a cloth side, and the mixture is put on the cloth side, and we hold it over the hole in question, and if it's positive, it will turn a gray, like a gray color.
Did you do that in this instance?
I did them for all, yes, and they all return negative.
So, meaning not positive for it having a ballistic event or being struck by gunfire, correct? Okay. All right. A47.
This is a mid-range photo where I've placed placards by the latex glove with handcuffs, the cell phone, the pack of cigarettes, and the keys in the garage.
And can you explain what the placards are used for, why you do that, and what it helps with?
The placards are just to identify what I would be collecting, and then the associated number, let's say 8.
Do you recognize that?
Yes.
What's that?
This is an expanded projectile.
And is it the same as what is in the...
Y'all stay tuned, stay tuned. We got the closing arguments coming up next.
The photograph here on A53, item number 5?
Yes.
What's this?
It's a close-up of this projectile.
All right, you can set that aside.
Thank you, Your Honor.
State's Exhibit C1.
Yeah, Columbus Police Cruiser 9031.
And C2?
A different angle of it on the driver's side.
Can you see the number up at the front? Kind of the front
You may.
side
Yes,
panel
sir.
there too?
9031 right here?
Yeah.
Yes.
C3?
The front end photo of 9031.
C5?
The straight on photo of the same cruiser.
C6?
The front passenger side of cruiser 9031.
C7?
The straight on photo of the same cruiser.
C8?
This is the front passenger door that is opened. I'm now starting to process the inside.
C9?
A photograph looking in the front passenger seat.
And do you know whose cruiser this is?
I was told it was Officer Coy's.
C10?
A photo still at the front door, front passenger door, looking across to the front driver's side.
C11?
This is going to be the front driver's side.
C12?
Standing at the front driver's side door, looking into the car.
See,
the absence of evidence is not the evidence of absence.
What?
Yo, big shout out to Chan Ma Black is Golden. Y'all show her some love, drop her some queen emojis in the chat. Always showing love and support. Never doubt it. Appreciate you, family. Y'all show her some love, drop some coins in the chat. Shout out to Gap Girl, got gifted with a membership and the $2. We have to make our chat substantial. Hey, I appreciate that. Y'all show her some love in the chat. Make sure you do that. Much love, much love, much love. Appreciate the sponsorship. And before we continue the rest of her testimony, I do have a little bit more of oh boy, I think it's a little piece of cross. It's not that long. We're going to get into that right now. Appreciate y'all, family. Y'all show us some love and appreciate the support. I appreciate the likes too, the subscribes, and all the love. It all helps.
Oh, gun, he's got a gun because you're lying?
No, sir.
Did you yell? Did you respond? Gun.
Thank you, Mr. Pearson. Redirect.
Hey, proceed, Your Honor.
You may.
Adam.
Yes, sir.
Yell, gun, he's got a gun because you're lying?
No, sir.
Did you yell? Did you respond with deadly force because you saw what you perceived as a deadly threat in his hand?
Yes, sir.
Describe what you saw in his hand.
Leading witness. No, overruled.
What did you see in his hand?
I saw silver, metal, thin in the front, thick in the back, coming up at me. A silver revolver.
When you were coughing, is that another term? Were you dry heaving?
I was dry heaving. I was about to be sick.
When you have you had a microphone on the shoulder, right?
Yes, sir.
Is it common practice, Adam, that when you're investigating something at a house, a dark garage, and stuff like that, get on the microphone and go, hey, I'm investigating a dark garage.
Absolutely
Just
not,
want to let
sir.
everybody know.
No, sir.
How many officers are out in the Division of Columbus at the midwatch at that point in time on runs?
I have no idea, sir.
Hey, send backup. I may have something. Something's not making sense. Have you ever done that?
Yes, sir.
When?
When it was needed, sir.
Why didn't you call SWAT in this situation as you were going up the driveway, Mr. Coy?
You don't call SWAT for a burglary, sir.
Mr. Pearson asked if he was complying. Your answer was he was partially complying, right?
Yes, sir.
Where was his left hand?
In the air.
Is that compliance?
Yes.
Was his right hand in the air?
No.
Partial compliance. You told Officer Detlier that something was not right, right?
Yes, sir.
Did a person ever come outside from the house while you were waiting with Mr. Hill on the street?
No, sir.
Didn't turn out to be right, did it? The fact that he told you someone's coming out?
Yes, sir.
Did a person ever come to the door or ever turn on a light inside based on the knocking?
No, sir.
Was the person parked in front of where you were dispatched to, 1054 Oberlin?
No, sir.
Wasn't right, was it?
No, sir.
Was the person parked in front of 1062 Oberlin when you pulled up behind the vehicle?
No, sir.
Where was the person parked?
1070, sir.
Wasn't right, was it?
No, sir.
Did the person go into 1070?
No, sir.
Wasn't right, was it?
It seemed odd, sir.
When the person went to 1062, was that right based on...
Leading the damn witness. What the hell are y'all doing right now? No, sir. No, sir. What the hell is this, an interrogation?
Your encounter at that point in time?
I wasn't sure, sir.
Wasn't right, was it?
No.
Did the tag come back to the area that you were dispatched to?
No, sir.
Wasn't right, was it?
No, sir.
A lot of things not right, right, Mr. Coy?
That's correct, sir.
Let's talk about contacts. I have contacts. Can you see the screen up there?
Yes, sir.
Because why?
Because I'm wearing my glasses, sir.
Okay. Can you read something? For the record, I have a cell phone in my hand. Can you read
For the
something
record,
from there?
you can't see, sir. For the record, he just said he can't see. He got eye vision problems.
No, sir.
So why is you shooting people knowing you can't see?
You need us to do that?
Yes, sir.
I believe on direct that you told Mr. Hill while you were there, correct?
Yes, sir.
You told him that you had to be there and talk to him because you were sent on a run.
Yes, sir.
How fast did this event occur from the time you started going up the thing when you first saw the shining light and you told him come out? Was it 10, 15, 20 seconds, sir?
Maybe a little longer.
The entire time, right?
Yes, sir.
Until the time when you saw him suck up against the car until he came edge and you saw the
Got him! Got him!
glint of silver steel. How long did that take?
Fractions of a second, sir. Sub-second.
Are you required to give a written statement?
No, sir.
Are you required to sit down with BCI agents and give an hour's interview?
No, sir.
Why did you do that?
I wanted to tell everyone what happened, sir.
When you tried to explain your encounter with the person that Mr. Pearson kept asking about, whether you saw a text or not a text, were you trying to explain what happened at the car?
Yes, sir.
When you were talking to the BCI people and wrote out your statement, were you trying to explain that the person made an X with his hand?
Yes, sir.
Okay. Is that in your statement?
No, sir.
The X in
yes,
the hand?
yes, sir, that is.
He did a what? He made an X or an X? Did he say X or X? Either way, he didn't do neither one of those. We saw it down. Man, let me put up the video on the side while this is wrapping up.
Both, correct?
Yes, sir.
If I'm sitting there and I put an X at my hand, where's the left hand going to be?
On the right-hand side, sir.
Where's the left elbow going to be if you're sitting in a car?
On the windowsill, sir.
Case is solved. You didn't use the word elbow, did you, in your statement?
No, sir.
You gave a 10-page statement, correct?
Yes, sir.
Did you try to put the basics of what happened that night?
Yes, sir, I did.
Did you try to answer every question truthfully and honestly as you remembered it when you met with the detectives or the agents?
Yes, sir.
Thank you, Adam. Thank you, Ron.
Thank you, Mr. Collins. Recross?
Follow up, just one question. Mr. Coy, you have a PA system in your vehicle?
Yes, sir.
How does that work?
It's outside the scope of any direct or redirect.
No, at this point, overruled.
Thank you.
You can ask the question.
Yes, you have a PA system in your police cruiser at that time?
Yes, sir.
How does it work?
There's a separate mic that you pick up that's not connected to the radio system.
And?
You key it like a mic and you would talk into it, sir.
And what happens? What's the effect of you talking into it?
It amplifies your voice.
Okay. So you can talk to a lot. It's really loud if you want it to be, correct?
Yes, sir.
Thank you. I have no further questions.
You may.
Why didn't you get on that mic and say, hey, potentially the person I'm thinking about, maybe things aren't adding up. Where the hell are you? Come out here. Come out here. Do you do that on a regular basis, Adam?
No, sir, we do not.
Have you ever done that?
No, sir.
No further questions.
Thank you. Anything else?
No, Judge. Thank you.
All right. You may step down at this time.
Thank you, Your Honor.
Oh shit, and I was talking on mute, huh?
Well,
I'm over here talking on mute the whole time.
A nice
My bad. Anyway, I was saying appreciate y'all. Shoot. I don't even want to repeat all of what I said. Let me see. But yeah, anyway, I was saying we're gonna keep it rolling. We got some more to go. I don't even know what I just said. Trying to remember it, make it even harder. I'll come back. Appreciate y'all. Let's just keep it rolling for now. My bad. I was on mute and lost everything I said. They killed Kenny.
That you're going to hear in this case. Okay, at this time, we're going to move to closing arguments of counsel. Closing arguments of counsel is not evidence. It is information that hopefully will help you as you are deliberating. Because the state has the burden of proof, the state will have two opportunities to close. So on behalf of the state.
Thank you, Your Honor. Ladies and gentlemen of the jury, I want to thank you for your time and your attention over this past couple of weeks. It's very important to us that you have shared essentially your lives with us so we could present this case to you. The case of State of Ohio versus Adam Coy. As you know, Adam Coy shot and killed Andre Hill. Andre Hill was born on May 23rd, 1973. He would have been 52 years old. He's not here for us to sit in between counsel tables, so I ask you to follow the judge's instruction when the judge says don't be weighed by sympathy or prejudice. Okay. We heard a lot about what happened this night on December 22nd, 2020. This case isn't about someone who is resisting arrest. The officers piled on him, put a knee on him or something like that, and he dies. This case isn't about that. This case isn't about someone who, shoots at the police, is involved in a high-speed chase and runs and flees from the police and is shot as a result of that. This case is not about someone who tells cops, I hate you, I'm going to stab you, I'm going to shoot you. It's not about that. It's about a man who was following police orders and was killed for it. We heard from Robert Ronker, Mr. Ronker. He was a 911 caller. He kind of set the events in motion. after Mr. Hill got to this address on Oberlin. He was that first house that you viewed in the jury view, and some of you were walking up the driveway and that sort of thing. That's where he lived. He saw Mr. Hill's vehicle there, didn't recognize it. Vehicle had been turning off and on for hours, so he called the cops. They actually relayed him to the police officer, the police number instead of 911, because it was that low level of an emergency. So when police officers get there, Mr. Coy, he gets there. You heard from Mr. Ronker that, yeah, he told Mr. Coy that the vehicle that he was after, or that he was looking for, was parked down the street. And he goes out and he tries to tell Mr. Coy something. Mr. Coy shoos him back to his residence. And then he says he hears the shots. You heard from Amy Detweiler, Officer Detweiler. She stated that she was been Adam's partner for her entire career. She had worked with him, worked around him. That she arrived on the scene shortly after he did, a few minutes later. Didn't notice anything weird. Thought that Mr. Hill was maybe sleeping in the vehicle or something like that. And then Coy says to her, something's weird. That's really all he says. Something's weird, something's off, something like that. And then they approach the garage. And they see Mr.
He was high. That's why he said something weird. Oh, something weird. Oh, I'm tripping out right now. I'm having a trip. My bad, my bad. All right, I ain't gonna cut in no more, but I had to. He was high. That's what it was.
I don't know what I said, but I was high every day for a whole year, and I was saying anything. I was saying done anything to get out of here. I was saying done anything.
Hill in the back of the garage. They shined their flashlights on him. You heard from her. And she said, come on, or Mr. Coy said, come out, show yourself. That's exactly what he did. He showed himself. And he shot 4 times. You heard use of force experts testify that an officer is responsible for every shot that they fire. Every shot that they fire. That when using force and evaluating how much force is necessary, they're supposed to evaluate what is happening. If it's too much force, ratchet it down. If it's not enough force, ratchet it up. But Mr. Coy shot and killed Andre Hill. You heard from Officer Ben Bradford, who said that he arrived on the scene a little bit later, didn't know what was going on. No one told him what was going on. Didn't know what he was walking into, and was there, just kind of standing around. Then an officer came by and said, pump his chest. So Officer Branford, got on Mr. Hill, started pumping his chest, attempting to use life-saving measures. Until the medics arrived. You heard from Paul Hill, medic. He arrived. Started pumping Mr. Hill's chest. Then they took Mr. Hill away. And the medic. You heard from Asia Chung. She was the crime scene search unit detective. She took evidence. She took photographs, as she does in your usual course. She didn't see what happened on the scene. She located some shell casings. But she collected the evidence of this officer-involved shooting. You heard from Dr. Daniels, Dr. John Daniels, who is a pathologist who does cases here in Franklin County, Ohio. And he testified that Mr. Hill died as a result of gunshot wounds. He testified to that, and that was his expert opinion. Then you heard from a use of force expert by the defense, Kevin Davis. He essentially looked at this case, determined that all of Mr. Coy's actions were within sound police practices. There was nothing wrong with them, that they were just fine. You heard from the defendant, who testified. He testified as to what says he saw and what his impressions were when he saw Mr. Hill coming out of that garage. But we keep coming back to the fact that fear does not equate to threat. Mistake does not equate to threat. That's where this boils down. We can't look into the mind of him. I can't open his brain and determine whether he was actually fearful or not, whether he was actually scared or not. But it actually doesn't matter. What matters is, would a reasonable officer on the scene at that time use that force? Use deadly force? And the evidence has shown that a reasonable officer would not have. You heard from use of force expert James Scanlon, who essentially did the same thing. He took Mr. Coy's statement, worked his way backwards, and justified the use of force by Mr. Coy. Said, yeah, it's sound police practices. Yeah, it's fine. Yep, it's all fine. What he did. The state put on a rebuttal witness, Seth Stoughton, who testified, yeah, a police officer can use deadly force if someone points a gun at them. Would you? He would lose all credibility if he said someone could point a gun at a police officer and a police officer couldn't use deadly force. But we got to look at the context. We've got to look at the surrounding circumstances. And when you do that, when you apply that to the law, Mr. Coy's guilty of the charges. Let's talk about those charges. We look at the offenses. Did the state prove beyond a reasonable doubt that the defendant committed the offenses? We go into murder. Again, you're going to have jury instructions that the judge is going to read to you and give you a copy when the attorneys are done talking. So you'll have that.
In this
You
trial.
want to take notes, go ahead, but you'll have the full definition. These are kind of like bullet points here. This causing death as a proximate result of a felonious assault. That is what count one is. There are a lot of different classifications of what we call murder. There's probably there's a lot, more than just one. This is the one. This is the offense that the defendant has committed. So don't get caught up in the title. Focus on the elements. So did he cause the death of Andre Hill? Yes, he did. Hopefully I don't have to spend too much time on it. It's on video. He caused the death of Andre Hill. He did not do it accidentally. He didn't drop his gun and the gun go off and it shoot. Yes, he did claim mistake, but that's different than accident. So he caused the death. As a proximate result, the defendant is responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. As a proximate result of committing a felonious assault. So the defendant committed a felonious assault and that caused Mr. Hill to die. What is a felonious assault? A felonious assault is causing serious physical harm. That's one way to do it. And I would submit to you that getting shot 4 times is serious physical harm. Or you can cause any physical harm with a deadly weapon. So this is an and/or type of definition. Serious physical harm or physical harm plus a deadly weapon. A deadly weapon is a gun. Deadly weapon can be a pipe, pole, knife, any of those things that can cause death. Here we're talking about the defendant's weapon. Cause of the death of Andre Hill. Count 2, felonious assault. You will be asked to decide if the defendant has committed that offense. The evidence shows that he has. Again, this was no accident. This was no accident. He has said he is mistaken, but it was not an accident. He caused serious physical harm, and he caused harm to Andre Hill with his deadly weapon. And reckless homicide, recklessly causing the death of another. Recklessly causing the death of another. His actions were reckless, ladies and gentlemen. They were reckless. From the time he got out of that police car to the time he walked down that driveway, everything in between was reckless. What was really reckless was shooting an unarmed man after he had just gotten out of a car, and he shoots that man, and his justification is that man had car keys that he thought was a gun, that he says he thought was a gun. Now,
What up, TSC? I see you, family. Appreciate you tapping back in. I seen you here early. First one before I even started. So I seen you, but I appreciate you coming, tapping back in. Let's get it.
if you find that the state on any of those charges has proven the defendant guilty beyond a reasonable doubt, then we move to their justification. I know some of you are thinking, well, how can a police officer be charged with, with felonious assault and killing somebody and reckless homicide? He's a police officer. They're supposed to get dispatched to scenes and shoot bank robbers and things like that. How can they be held responsible for these types of things? Because we expect them to do that. Yes, but we only expect them to do it in situations where it's reasonable. So after you've seen the video and you've seen the evidence, the state has proven those bare elements, those elements of the defendant committing those crimes. Now we move on to the justification. Was he justified in his role as a police officer to do what he did? And when we look at whether he was justified as a police officer to do what he did, we look at the reasonableness aspect of it. The reasonableness aspect of it. And it is the defense's burden, not ours, to show that he acted reasonable or not. State feels he's not acted reasonably. The evidence shows that there has not been anything or enough shown in trial to prove by a preponderance of evidence that the defendant acted reasonably. When you've heard about in voir dire, what does preponderance of evidence mean? That means more than not, 51%. So if you're really not sure, then the defendant has not met his burden. They have a burden to prove to you. They have to prove to you that this was justified. They have to prove to you that it was reasonable and that a reasonable officer would have done the same thing. And that's outlined in your jury instructions.
The absence of evidence is not the evidence of absence.
What?
Hey, yo, show some love to TSC and Chad My Black is Golden, sponsoring the stream for the night. Appreciate y'all. Y'all dropped them some coins and some crazy emojis. Go crazy. Appreciate y'all. Y'all go show them some love. Let's keep it rolling. Shout out to TSC with the $2 sticker. Appreciate you.
Test for reasonableness is an objective one, not a subjective. Not what that individual thought in their own mind is what a reasonable officer would have thought. The question is whether an officer's action was objectively reasonable in light of all the facts and circumstances confronting him without regard to his underlying intent or motivation. So, did the state prove beyond a reasonable doubt that the defendant committed the offenses? I believe the evidence shows that it has. The video shows that it has. He did not do it by accident. He knew what he was doing. He knew that when you shoot somebody 4 times center mass, whether you classify it as stopping the threat or something else, the person is likely to die from it. And I get it. Officers are trained to shoot center mass. I'm not saying that he should have shot a limb or a foot or anything like that. I'm not saying shooting center mass is not what he was aiming to do. He was aiming to shoot center mass. And when you do that, you can reasonably conclude that someone's going to die from getting shot center mass. So again, the evidence shows that the defendant has committed the crimes of murder, this category of murder, which is causing the death of someone as a proximate result of committing that felonious assault. Once you have found that, then you move on. Did the defendant prove by preponderance of evidence that he was justified in using deadly force? Move on to that other item of justification. If no, then if they have not proven by preponderance of evidence, then your verdict should be guilty. If yes, if they have proven by preponderance of evidence that this officer was justified in what he did, then we move on to not guilty. And that applies to each of the charges. And if you find that the state did not prove its case beyond a reasonable doubt, then your analysis stops there. You don't even have to move on to their preponderance standard. The state has presented evidence of Mr. Coy shooting and killing Andre Hill without justification. You've seen the video. You will have the video and evidence. The things that Mr. Coy says about that interaction that night, they're not really supported by much at all. Blading, Mr. Coy classified it as being in a boxing stance. You don't see that on the video. You see Mr. Hill following police orders, walking to where he was called, with the flashlight in his eye also. So if you've ever been in a dark space, I'm sure all of you have, and someone shines a bright light at you, that's going to obstruct your vision a bit. That may impair how you're walking to someone. But he wasn't stumbling or falling or blading. You wouldn't be able to see that from the video. This is a man just walking. As I talked to the defendant while he was on the stand, we had an exchange. And that exchange was because the evidence shows that the defendant shot and killed an unarmed man following police orders. And then he had to work his way back. He said moments after the shooting, he says, I gotta find what I missed. That's what he said on the stand. He confirmed that. Those weren't my words, those were his. I gotta find what I missed. This is moments after the shooting. That's when this started, ladies and gentlemen. Moments after the shooting.
And what did he do right after? I gotta find what I missed. That's when, as we showed in the previous ones, that's when he grabbed them pills. And that's when he went and threw them pills in the grass. He grabbed them pills, or whatever it was. I don't know if it was pills or what it was. But he grabbed some shit out of his car and went and threw it in the grass. That's what he missed.
He said,
part of it, at least.
I know I can't just shoot an unarmed man for no reason walking out of a garage. So what are the things I can point to justify that? He wasn't concerned that a burglary was happening. He wasn't concerned that there were hostages in that house. He wasn't concerned with this. He saw Mr. Hill waiting. That was perfectly normal to him. He was fine with it. He was going to wait till Mr. Hill left and then called in and went and traveled somewhere else and finish his lunch, as he told you. Then Officer Detweiler arrived and he goes, better do something about this. So let me go and see where Mr. Hill is and what's going on. He sees Mr. Hill in the garage, orders him out. And then for whatever reason, a reason that none of us may ever know, he decided to shoot Andre Hill 4 times, kill him. And then he goes, oh, fuck. He says that. He says those words. Because he realizes he had no justification. There was no reasonableness to it. And when he goes down and he's talking to Officer Barsadi and he says, I gotta find what I missed. That's where this starts. I talked to him. What did he say that was weird? What did he say that I can say was weird? He comes up with these things you can latch on to, that he can sell to you. It is tragic, ladies and gentlemen, all the way around. It's tragic. I'm not trying to tell you that this defendant woke up this morning saying, I'm going to kill somebody. I'm not saying that. I'm not saying that he's the worst human being on the planet. I am not saying that. I'm not saying he's a rogue cop who goes out and he kills every potential person he comes into contact with. I am not saying that. I'm not bringing that to you. We look at his actions, and he killed an unarmed man and didn't have reason to. And that justification defense he made up after. Ladies and gentlemen, when you get this case, look at the body again. Look at all the evidence. And when you do, you will find him guilty of all of the charges. And you also find that the justification defense, it's not common sense. If you follow your common sense, it just does not fit. Thank you.
Thank you, Mr. Pearson. On behalf of the defendant?
Your Honor, I'm going to need the OMO.
Okay.
You want to set that first?
Dudley do right. All right. Before we get into old dude, we got a little bit of the rebuttal from the who was that from? The expert witness called to testify in Adam's murder. I don't know. It's a lot of timestamps and it's a lot of time in there, so I'll play a little bit of it, not too much, unless we get some more specific spots. So, Aaron, if you got some more specific spots, then let me know. But other than that, we get into it. We play a little bit of it, and I'll skip around until we find something. But let's make it happen. Appreciate y'all. Let's go.
Case, and they have a witness. State may call their witness.
Thank you, Your Honor. This time, the state would like to call Seth Stoughton.
Swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, as you shall answer unto God, under the pains and penalties of perjury.
I do.
You may be seated. It's important that you speak into the microphone so that the ladies and gentlemen of the jury can hear.
I understand. Thank you.
So for the record, if you please state your name, spelling your last.
My name is Seth Stoughton, Stoughton.
Thank you. You may inquire.
Thank you. Good morning, Mr. Stoughton.
Good morning.
Tell us a little bit about yourself, please.
I am a law professor at the University of South Carolina, the Joseph F. Rice School of Law, which I'm contractually obligated to call it that. I'm also the faculty director of the Excellence in Policing and Public Safety program at the law school, which is a legislative and grant-funded program that works with police agencies in South Carolina and beyond on collaborative professionalization, providing executive-level training for the most part. I've spent the last 13 years now as an academic studying policing. My focus is primarily on police procedures, tactics, use of force. Prior to becoming an academic and going to law school on that path,
To the last question regarding what happened after the shooting, it's not part of your consideration in this matter and should be disregarded. Okay, you may inquire.
Thank you, Your Honor. Professor, we talk about generally recognized police practices. What are those?
Sure. So generally recognized or generally accepted practices in policing are the standards that we expect, the minimum standards that we expect officers and agencies around the country to meet. It's a little bit complicated in the United States because we have more than 18,000 different agencies, and some specifics can vary very much from agency to agency or state to state or region to region. But when we're talking about generally accepted practices, we're talking about those principles and practices that have bubbled up from the way policing is actually done to the point where you would expect any well-trained, competent officer anywhere in the country to look at that generally accepted practice and say, yeah, that's more or less how we do things.
Okay. As a matter of generally accepted police practices, when can an officer use force?
In policing, it's generally accepted that officers can use force when there is an imminent threat to something that the officer is lawfully trying to do, some lawful objective that the officer is engaged in.
All right. What is an imminent threat, Professor?
Policing has defined 3 parts to an imminent threat. An imminent threat exists when the individual is reasonably perceived as having the ability to cause whatever threat we're talking about, whatever harm we're talking about. And I'll define these terms in a second. As having the opportunity to cause whatever harm we're concerned of, and as having the intention to cause whatever harm we're talking about. So ability is really the physical capacity to do the thing. If we're thinking about a threat of escape, that is, the officer has a lawful interest in apprehending someone, and we're worried about the person evading apprehension, physical ability would mean the person is physically capable of, for example, running away, which may be the case if they're standing up and generally fit, and may not be the case if they're in leg shackles, for example. And when we're talking about physical ability to hurt an officer, when that's the relevant harm, we're looking again at the person's physical capacity, right? So someone who does not have a knife does not have the physical capacity to stab or slice an officer. Someone who does have a knife does. When we're talking about opportunity, we're talking about whether that threat could occur, whether someone is vulnerable to that threat. So even if someone is capable of running away, if they're sitting on the ground surrounded by officers, they may be physically capable of running away, but they're really not going to be in a position to cause that harm, right? They're not. There's no opportunity for them to do so. When we talk about physical harm again, we can imagine someone with a knife who has the physical ability to stab an officer, but if they're 50 feet away, there's no opportunity at that point for them to do so. Maybe they will be if they're closer, but not at that point. And the last point is apparent intention. That is, looking at the person's behavior, could we reasonably perceive that this person looks like they want to cause whatever this type of harm is? If someone's just standing and interacting with an officer and they could freely run away and they have the physical ability to do so, but they're continuing to just talk with the officer, there's no imminent threat of escape, even though there's physical ability and opportunity. And similarly, if someone has a knife and is within arm's reach of an officer, but they're just cutting up vegetables in the kitchen while they're chatting with the officer, they might have ability and opportunity, but there's no intention to think that that person intends to cause that particular harm. So you need all 3 elements, ability, opportunity, and intention, to get to the point of having an imminent threat, and that's what justifies the use of force. If you're missing any element, you have what we call in policing risk, and there are other things officers can do to mitigate risk, tactics and communications, for example, but it's not appropriate to use force in the absence of an imminent threat. Believed it, we're asking whether it was reasonable, whether it was professionally appropriate for them to have believed that or not. A simple example from an actual case, when an officer described someone as threateningly holding a golf club up above as if to swing, but there's video footage that shows that never actually happened. You can believe that the officer truly believed, that is, honestly made that mistake about what happened. You don't have to, but let's assume you do, right? You think, okay, the officer is honestly describing what she perceived in that case. But when you look at the objective evidence, you say there's no support for that belief, right? That is an unreasonable mistake, even if it is honest.
Okay, thank you. Going to fear, does fear factor into the equation of an officer being able to use force?
Now, hold on now. We got a new one now. We got a new record. This one charges, what you say, Aaron, $320 per hour. The last one we had was $250. He done stepped it up a whole nother, almost $100, and a whole nother $70. $320 an hour. Crazy for testifying for this.
No, not in any direct way. Officers have to manage fear, especially when there is a threat. But just because someone is afraid or experiences fear does not mean that there is an actual imminent threat that justifies the use of force. And vice versa, just because there is an actual threat does not mean that officers are always afraid. They are human. They are perfectly prone to being afraid and feeling fear. But we can't predicate the use of force on the existence of fear or the lack of existence of fear, because that's purely emotional, as opposed to threat being something that we can identify about the world. The particularly Fear is internal to the officer. Threat relates to something that the subject or the individual is doing.
Thank you. One last item before we get into further details about this case. What about context? How is context important in these situations, Professor?
Context is really, really important in policing because policing are often operating, officers are often operating in ambiguous situations, right, where we don't exactly know what someone's movement, for example, may signal.
You may inquire. You may.
Thank you so much. Mr. Stoughton, just a couple more topics.
Sure.
Get through this. You were never trained to be a police officer in Ohio, correct?
Correct.
Never OPATA certified?
Correct.
Never trained officers in Ohio with regards to use of force training with regards to OPATA standards?
Correct.
And in your report, Mr. Stoughton, on page 26, and I think you talked about it with Mr. Pearson on direct, and I'll get you to there. It's a well-known policing that most residential burglaries occur during the day when the occupants of the home are less likely to be present, okay? And you mentioned that this started around 1:30 a.m., correct?
Yes, I'm looking for that spot in the report, but yes, yeah, there it is, yep.
Bottom paragraph, yeah. So, and again, you're relying on national standards, correct? Or national studies?
Yes.
Okay, so you didn't, Columbus has a website that has a public record of reports or runs on burglaries or thefts. Were you aware of that?
I think I was aware that it existed, but but not more than that.
So you didn't go and analyze and look at a time frame with regards to this area or anything like that?
No, I did not.
Okay. And you would agree with me that officers who patrol that area would know and have better experience or with regards to when property or burglary crimes are higher or lower depending on the times of the year? You would agree with that, correct?
I would hope so, yes.
Absolutely. And so with regards, if I told you that I've shared this, if I've told you that within 12 days prior to December 22nd of 2020, that there were 8 burglary property thefts runs, and 6 of them were between the hours of 11 p.m. and 5 a.m., and only 2
No, I would have no bit.
What the hell do that got to do with anything? Why y'all even talking about that? Why is there no objection? What does that have to do with you out here shooting people?
To disagree.
That's a situation where the local situation does not conform to the national standard that you list in your report.
I would need to delve into the data to define that, but sure, maybe.
Okay, all right. Now, you agree with me that an officer can be mistaken if they see a deadly threat, correct? And they react to a deadly threat.
That can be a mistake, sure, yes.
Absolutely, okay. And believing that you see in a silver revolver could be a deadly threat, correct?
I'm sorry, are you asking whether that can be a mistake or whether seeing a revolver can be a deadly threat?
Both. If you see a revolver, that's a deadly threat.
It can be, it isn't necessarily. People can lawfully carry or even hold weapons while interacting with officers, but it certainly can create a deadly threat situation, sure.
Let's just get right to the point. I'm not talking about all those other things. Just if an arm's coming up and an officer sees a gun, that's a deadly threat, correct?
Yes, I think it is reasonable to conclude that, yes.
Gun could be on safety, correct?
Sure, could be.
Gun could be unloaded, correct?
Yeah, sure.
Gun could be can't work.
Yeah, could be fake, sure.
And the person who had that gun might know that, correct?
Yes.
But the officer would never know that, correct?
Absolutely.
Now, same thing. That's an actual threat. With regards to a perceived threat, if an officer perceives a deadly threat and believes there to be a silver revolver, then that could be reasonable in certain contexts or situations depending on the facts, correct?
It absolutely can be reasonable, yes.
And then on page 40 of your report, you kind of go through that process on the second to last paragraph.
Yes.
Assuming for purposes of analysis that a reasonable officer in Officer Coy's position could have reasonably mistaken Mr. Hill's keys for a firearm, then a reasonable officer could have concluded that he had the ability to cause the death or great bodily harm, correct?
Absolutely.
And you believe that that's the job of the jury to determine whether or not that mistake was more likely than not?
I do, yes.
More likely than not reasonable?
Whether it was reasonable, yes, correct.
Mr. Stoughton, that's all the time I have, or questions I have for you. Thank you very much.
Thank you.
Thank you, Mr. Collins. Redirect.
Thank you, Your Honor.
I will work backwards. I believe the
Daddy, I
last
like when you scrambling and scraping for shit. I like that.
exchange of questions with Mr. Collins boiled down to anytime an officer sees a gun raised at them, it would be reasonable to interpret that as a threat, correct?
I think that's a little bit of an overstatement, but in the field type situation, yes, if an officer sees someone who is actively raising a gun to point it at them, I think it's reasonable to conclude that that's a threat.
Would it also be true to say anytime an officer sees an individual with a gun, not raised at them, but with a gun, it would be reasonable to perceive that as a threat?
No. No, there are other officers have guns. People can lawfully carry guns. They can lawfully handle guns in front of officers without necessarily creating a threat.
Okay. So is it your testimony today that it depends on context?
It depends on context, yes.
Ain't your money.
And as was pointed out in your report, in that second to last paragraph on page 40, there's a lot of, I mean, there's a could there in italics. Does that need further explanation? Or I guess, can you explain that a little bit further?
Sure. So as I think I indicated, there's no objective identifiable evidence as to what the keys look like in Mr. Hill's hand. It's not on camera. There is no, other than Officer Coy's description, there is no basis for saying this is what they look like or did not look like, this is what they reasonably could have been mistaken for or not reasonably mistaken for. So that paragraph that, that was read in Cross follows a paragraph that talks about assuming for the sake of argument that an officer could not have reasonably mistaken the keys for a weapon. There is insufficient information in the record for me to say whether to say what the keys look like or whether it was reasonable just on that basis to conclude that the keys looked like a weapon or did not look like a weapon. As we talked about before, I think there's a substantial amount of evidence in the record about the context that would lead me to conclude that one should not assume, right, in an ambiguous situation, the context does not support the conclusion that that Mr. Hill was holding a weapon. But that's different than what did the keys actually look like, and I don't know. Ultimately, that's a factual determination that is outside the scope of expert testimony that
Up to you, Professor.
Okay. So the first, I suppose the first thing that, the first part of my conclusion in this case is the later statement by Officer Coy, now Mr. Coy, that he believed that Mr. Hill was engaged in a burglary or part of a burglary in progress at this residence. In my opinion, that conclusion is not consistent with generally accepted practices in policing. That is, the evidence does not sufficiently support that conclusion. I can dive into more detail.
Yes, please.
The other. Okay. Is the evidence does not sufficiently support that conclusion. That is, the evidence does not sufficiently support that conclusion.
Have a good night. Have a good night. Have a
I can dive into more
motherfucking
detail.
good
Yes, please.
night.
Okay. So reviewing the evidence, particularly from Mr. Coy's statement, we have the initial phone call from a complainant about what came in as a disturbance and what Officer Coy understood to be more of a suspicious person. The initial conclusion that Mr. Hill turning his vehicle on and off was probably an attempt to stay warm. A brief interaction where Mr. Hill apparently explained to Mr. Coy that showing him the cell phone and saying, I'm waiting for someone at this house or something like that. And then Mr. Coy returning to his vehicle and just sitting in there in case the caller came out or made additional contact and just to sort of keep an eye on things. That's all pretty normal. That's a pretty normal interaction that really would strain credulity to say there might be a burglary in progress at this particular residence, in particular part because of how we know that residential burglaries usually occur. Typically, we have forced entry for residential burglaries. Typically, they're fairly fast. That is, Typically, we don't have people actually go through and clear out an entire house of stuff. They grab small or high-value items, electronics, cash, medicines, jewelry. The idea of a lookout at a residential burglary is really more fiction than practice in policing. And we have that coupled with pretty straightforward explanation supported with at least some amount of visible evidence that I'm waiting for someone in that house. When Mr. Hill later entered the garage, again, that's pretty consistent with the explanation that he gave, that I'm waiting for someone in the house. I'm waiting for someone to make contact, or I think the text message might have said something like, I'm...
Yeah, sustained as to what the text message said.
Oh.
Yeah, just don't say the contents of the text message, please.
Yes, thank you. So we have behavior that...
Hold on, so it's sustained, so ain't that supposed to be stricken, or ain't that supposed to be removed? What, they just keep going from there? They just continue the question? I don't see that often. Ain't they supposed to re-ask the question or start over? Because what part do you separate it at? How do the court reporter know where to separate it at? Not that we understand by common sense, but you can't assume. They can't just assume where you want to separate it at.
Is more consistent with perfectly innocent behavior than indicative of criminal behavior. Now, there are some indications of nervousness that Officer Coy's statement described, and nervousness is a relevant factor, right? As officers interact with someone, they certainly are aware of how that person is responding to them. But nervousness is a little bit tricky because officers also know that it's not unusual for someone to be nervous as they're interacting with an officer, and particularly when they're being asked to account.
And I don't even mean stricken. Like, I don't mean they have to strike it. Aaron said the defense has to ask to strike it. So even if they didn't have asked to strike it, you have to start over to understand where it stopped at, because what part was sustained? What part was objected to? So what part are they talking about now? Where did it stop at? Where did it end at? You know what I mean?
For their behavior in some way, like, what are you doing here this evening, right? So although I certainly would not discount indicators of nervousness, it's also important to not, and this is common in policing, it's important to not exaggerate the relevance or salience of someone being nervous. When we get to the point where Mr. Hill has walked by Officer Coy's vehicle and
Professor?
Also, I'm sorry.
I'm going to interrupt with a question that happened sequentially before that.
Sure.
Do you take any note of the fact that Mr. Coy never asked
in 20 when Quinlan observed those problems 12 years ago? Well, we asked the city's Department of Public Safety that question, and in 2008, Officer Coy was placed on a performance improvement plan, which he successfully completed and showed improvement. They said in 2012, he was also suspended for 160 hours after an investigation for use of force, with the Department of Public Safety saying they are a little bit limited because of the collective bargaining agreement with the FOP. Harry, after a certain period of time, discipline records must be purged and can no longer be used when discussing matters of current misconduct. I was told this is a weakness in that contract recognized by the Safety Advisory Committee, and is something that both Mayor Andrew Ginther and Chief Tom Quinlan are supporting, a change to that contract so that those records stay for an employee's entire duration with the Division of Police.
It's been way too long, but I'm glad that it's over. I mean, it won't bring Andre back, but hopefully it will set a precedent across the board for everyone else, that this is not something that we can tolerate.
Completely shocked murder. Completely shocked. I thought in this county perhaps a mistrial. Mr. Coy's dying. Simple as that. Mr. Coy is dying. He will die in prison.
This is over. Basically, I'm just happy that we got the verdict. The jury saw this right. We're just happy this day is over.
In coming back.
Thank God that they saw everything, that they were able to actually see what was. We're really happy. All the distractions.
We, the jury, being duly impounded and sworn, who find the defendant Adam Coy guilty of murder.
This sent a message to every officer in this county that your split-second decision can now be led to murder. It is absolutely insane, and we are shocked by it.
Former CPD patrol officer Adam Coy immediately taken into custody, convicted of murder.
Thought about it.
There's a lot before them, and they really gave it the necessary consideration that this type of case deserves.
It's been nearly 4 years since Coy shot and killed Hill. Since then, he has been diagnosed with cancer, and according to his and killed Hill.
Consideration that this type of case deserves.
It's been nearly 4 years since Coy shot and killed Hill. Since then, he has been diagnosed with cancer, and according to his attorney, is still undergoing some treatments.
Well, isn't this a nice surprise?
Let's keep it on rolling. Let's get to these closing arguments. They pretty long, so I want to try to get through them. Appreciate that adventuring, Aaron. Appreciate that. That was a good addition. I ain't mad at it. I appreciate that. I'm sure there's still some more I could dissect out of that. I seen it earlier too. That's what's crazy is I seen it, but I didn't click on it because I was like, man, it's already like 3-4 hours. But I'm glad you brought it back up because it was a good addition. So I appreciate that.
You may.
Thank you very much. May it please the court, Madam Court Reporter, Adam, Ms. Stevens, Mr. Pearson, Ms. Amlin. Good afternoon, ladies and gentlemen of the jury.
Good afternoon.
I'd like to thank you as well. A little bit different thank you. You stood up in the beginning of this process when the judge swore you in, and you took an oath not to form any conclusions or form any opinions until you heard all the evidence, until you've seen all the evidence, all the arguments, and the judge's instructions. Now, as you know, we've been a bit busy, but we've tried to watch you, and I do believe you kept that oath. And for that, I thank you, because without you keeping that oath and performing your civic duty, we wouldn't have the best criminal justice system in the world. I thank you for that, and I appreciate it. Closing arguments. Put the government's case to the test, show you what our case is about, ask the tough questions. We now know what the government's theory, that somehow he shot an unarmed man and made the entire thing up after the fact. Okay. That's perverse, ladies and gentlemen. That's desperate, ladies and gentlemen. That's the government, ladies and gentlemen. Ms. Stevens told you in the opening that the theme of this case is one of reasonableness, one of justification, all right? One of a mistake was made and whether or not that mistake was reasonable. That's what this case is about, ladies and gentlemen. I'm going to do my little chart again that you saw in openings. Okay. Not for an unknown reason, not for something that's kept secret, because he saw a deadly threat. He perceived a deadly threat. So this case is a bit different, but it's very simple, ladies and gentlemen. It's very simple. It's a different analysis because first, as the chart says, you have to analyze whether or not the state proved beyond a reasonable doubt each and every element. Specifically, what did we tell you in opening, in voir dire? Mental elements, okay? No one's challenging the date, the time, the county of Franklin, it was Mr. Hill, it was Mr. Coy. Those are the other elements that they must prove.
But do you have to actually analyze if there was actually a deadly threat? Like, can they just be like, oh, there's a deadly threat. Oh, it's a guy. He looks scary. I was scared. Oh, my gosh. I don't know. I was high on pills. I was scared. There's a deadly threat. Like, do you actually have to prove there was a deadly threat? Or do you just have to feel like there's a deadly threat? Like, why would you even argue some stupid shit? And then you go the complete opposite when it's somebody else on trial. But y'all fight like this for cops.
The only thing that we're challenging that the state did not prove beyond a reasonable doubt. Proof of such nature to rely upon it in the most important of your own affairs. Surgery for a loved one, care for a child. Okay? The mental elements. Recklessness. They have to prove recklessness beyond a reasonable doubt. At what point in this trial did you hear the term reckless ever used by any of the witnesses by the government, including Seth Stoughton? At what point, ladies and gentlemen, was there any evidence that our client was reckless? Recklessness, the mental element, is a heedless indifference. Disregarding a known risk, okay? Disregarding a known risk. There's no evidence of that. They haven't provided that. Recklessness, ladies and gentlemen, is different than knowingly. They put two theories of the case up on a board because they don't believe in their own case. Knowingly standard is a different component than recklessness. I'd submit you can't have both at the same time, ladies and gentlemen. When he decides to pull that trigger, you can't have recklessness and knowingly at the same time. They're competing. Now, what he didn't tell you just then about the mental elements, because he didn't go into them, is that at the time my client fired, What was his intent? The next step is everyone who testified from the Columbus Police Department, the two experts, is that at the time my client fired, what was his intent? The next step is everyone who testified from the Columbus Police Department, the two experts, what are they trained to do? I asked every one of them. Are they trained to injure? No. Are they trained to kill? No. They're trained to stop the threat. If they fire once and miss and the threat stops, that's what they're trained to do, to stop the threat. They don't form the intent to cause serious physical injury with that. Mr. Pearson just said, oh, yeah, I'm not asking them to shoot a limb or something like that. That's exactly what he's saying. They don't form that intent when they fire their weapon. That's not what they're trained to do. They don't form a reckless intent when they fire the weapon. They're trained to react to a deadly threat, and that's the only time you can, ladies and gentlemen. A perceived deadly threat.
Ain't your money.
What known risk was put out there by the government in its case in chief? There is none. Zero. Throw both up there. Hope you guys will compromise and go to that. Look at their witnesses. Their own witnesses show that it wasn't reckless, or that it wasn't knowingly. Why? Officer Detweiler. What did Officer Detweiler tell you? I said, had you perceived the same threat, what would you have done? She said, I would have shot. I would have shot. She couldn't see that side of the body. That's why she didn't shoot. Had you seen that? Everything about Officer Detweiler, was there anything reckless about her testimony? Was there anything reckless that she did in that situation? Because she said I would have done the exact same thing. Did you believe Adam Coy thought, an honest belief that he had a silver revolver in his hands? Absolutely, she said, 100%. Now, don't just listen to her word. What about Officer Branford? Police tactics. Officer Branford, remember, was sent out on a robbery run, lights and sirens, right? He's heading up there. It turns out it was a domestic disturbance, something a lot lower. What do I ask him? Hey, had you been encountered someone who presented a deadly threat to you, would you have fired? He said, absolutely. That's what we're trained to do, to stop the threat, not to injure. And there's nothing reckless about what he said as well, ladies and gentlemen. That's their witnesses. Now, ladies and gentlemen, if they don't prove their case and it's a no beyond a reasonable doubt, you stop there. It's not guilty, right? We all agree on that. All right. If for some reason we don't concede that you do believe that they prove their case beyond a reasonable doubt for the mental elements, then you have to examine our burden. Okay, our burden. Whether or not we prove justification beyond a preponderance. And again, how about Mr. Stoughton? Beyond a preponderance, he acted like he'd never heard the term before, and he's a lawyer, and he teaches law students. More likely than not, ladies and gentlemen, he didn't know that that's the standard in Ohio to judge a mistake. That's why he told you, oh, gee, more likely than not. Oh, geez, I've never heard it that way. Because he doesn't know the law in Ohio. One smidge over 50. It's not 51%. It's more likely than not a tipping of the scales, ladies and gentlemen. And please hold us to that standard if that's where you are in your analysis. We have to prove two things. More likely than not that Adam Coy had a subjective belief that he was in imminent fear of serious bodily harm and injury. Okay? It's not afraid of the situation, ladies and gentlemen. It's an imminent fear of receiving bodily harm or serious physical harm or deadly threat. That's what the fear is. And you heard Kevin Davis say there is no greater fear than someone leveling what's perceived to be a weapon at an officer. And the best part about the government's rebuttal case is no matter how Mr. Stoughton defines threat, ability, opportunity, intent, you won't find that in the jury instructions, ladies and gentlemen. You won't find it. That's why Mr. Scanlon and Mr. Davis said, do you agree with his report or not? Well, I agree with parts, but not parts, because he makes up his own standard.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
That's why Mr. Scanlon and Mr. Davis said, do you agree with his report or not? Well, I agree with parts, but not parts, because he makes up his own standard. He makes up his own definitions, because he's got to create that in order to start from a premise and work backwards. The second thing now that we have to prove is more likely than not was the decision to use deadly force reasonable based on the totality of the circumstances from a reasonable officer at the scene in his or her shoes, experiencing what they perceive, not what could have, should have, would have done with hindsight of 2020, but could have believed the need. That's the issue that you examine more likely than not. All right, let's go through and let's talk about our burden, okay? Let's look at the first prong. The first prong we have to prove, more likely than not, that Adam believed he was about to be shot at. Okay, it's that simple. All right? We have proven that more likely than not, ladies and gentlemen. How? He had a subjective belief because he told you. He told you he believed and perceived a gun was coming, okay? So that's one way we prove it. How is that corroborated? He announced it. He announced, gun, he's got a gun. No matter how much they want to say he made up a story, he announces it and Amy Detweiler hears it before the shots. Do you honestly announce something if you don't perceive it? So was he actually lying from that part as well, knowing that he was going to shoot on her man and announce gun? That's how preposterous their theory is.
Is that not part of your training? Do they not tell you, hey, if you want to shoot a guy and you're feeling trigger happy, just yell, gun, and everybody will shoot and then you'll be justified. The fuck?
He tells you what he sees. He announces it. We have proven more likely than not he had a subjective belief that he was in danger of serious bodily injury or death. That's the first part, his belief. All right, second part, all right? Now, the second part is bigger. It's bigger than what Mr. Pearson made it out to be. It's bigger because it contains multiple things about reasonableness, okay? So, we know in hindsight that there was no weapon, correct? We all agree. We know in hindsight there was no weapon. So now we have to look at the totality of the circumstances. You have to put yourself in Adam's shoes and determine whether or not the mistake is more likely than not reasonable. Now we'll go over the police terms for that, but just using your common sense, when you put yourself in those shoes, was it reasonable using your common sense? It's pitch black out. You can't see in that garage. You see the body-worn camera, how dark it is, okay? There is no light on. It's almost 2 a.m. Close confines, not a lot of room from the car to the other side. Duty to investigate. No matter what Mr. Stoughton says about a person in a garage that they don't have the ability to investigate, every single police officer told you that they had a reasonable suspicion to investigate in that situation. You can't see the full body. There were commands given. There was partial compliance. There was a left hand up, not the right hand. There was blading, and I'll get to the body-worn camera, ladies and gentlemen, but remember, the body-worn camera only had a certain amount of look back. Adam and both Officer Detweiler described for you many events that happened in the back of the garage that aren't on the body-worn camera, okay? That aren't on the body-worn camera. And I'll get into that of what a camera sees versus a human eye sees. Using your common sense, bladed, okay? Did it, at any time prior to this, to Mr. Hill coming to the car, did my client pull his weapon out? No. At any time when he said, hey, where you going? Come back here. Did he pull his weapon out and draw down on him? No. He wasn't reckless. He was reasonable those times. And an entire interaction. Once he sees, ladies and gentlemen, the glint of steel, that's a term because it's a Supreme Court term. And Mr. Professor's like, oh yeah, I think it's in one of those cases. You don't have to wait to see the glint of the steel. My client saw the glint of the steel and reacted, ladies and gentlemen. Reasonably. Was the mistake reasonable? Use your common sense. Ms. Allen, may I trouble you for the keys? What else using your common sense?
Bologna taquitos. Bologna slice wrapped up with a cheese slice. No frying necessary.
They don't show them to you. When you untangle them, we had to measure 8.5 inches. We had them plumped and stuff like that. Okay?
There you go, family. Look, there you go. There's your gun. The evidence will show. There's your weapon. That's why he was scared for his life. There's your weapon right there. He was full of them bologna taquitos and shit. He saw that weapon. He was popping them pills. And yeah, so there you go. There's the what they call it, the revolver. I forgot what they even called it. The pistol, I don't know, whatever the fuck they called it. There you go, right there. That's what he got shot for. And the thing was, how did you see that if his hand was covered though? How do you see these keys shining if his hand was hiding behind him? You said his hand was hiding in his pocket. So how did you even see those? Y'all didn't see those until after you shot him and tried to make it like that was the reason. Man, fuck out of here with that bullshit. The evidence is gonna show. Where the evidence at? I don't know. I ain't even seen. Oh, points actions. Here we go. Evidence. Yeah, the evidence is gonna show.
The evidence is going to show that anything that I may have said, they exacerbated it.
Common sense. Just using your common sense. Do you think these could be mistaken in the hand of a person as the hand comes up? We can't tell you how they were being held. We can't tell you if it was a clump. We can't tell you if this was there, okay? But is that a reasonable mistake based on these keys?
There you go, revolver. Do those keys look like a revolver? Thank you, no one. Do those keys look like a revolver to you? And also, the keys was not shown. It didn't even show them, not in the video, not on the cam. He didn't even see them. He said his hand was covered. You didn't even see that. So how did it look like a revolver?
If they're all black, of course not. If there was no metal or silver, of course not. Okay? And remember, they're missing two things here that were given back. Using your common sense, ladies and gentlemen, is the mistake reasonable? Their own expert admitted, well, yeah, in hindsight, he had the keys in his hands. Okay? They're silver, they're metal. Regardless, compare that to the picture of the revolver I told you. We talked about this in voir dire, the difference between a semi-automatic, shotguns, and revolvers. I showed you a picture of a silver revolver. Most of it's silver. And about the same length, depending. And what did Adam describe? I saw a short thing with a bigger thing in the back. That's what he described. Is it more likely than not a reasonable mistake? Now, if he said, oh yeah, he had a black semi-automatic in his hand, or he had a gun in his, a semi-automatic in his hand, or he had an Uzi, or he had an AK, or so, of course that wouldn't be reasonable, ladies and gentlemen. Of course not. Here's the best thing. What have they shown that it's not reasonable? How is the mistake not reasonable, ladies and gentlemen? We've shown way beyond a preponderance, more likely than not, that the mistake was reasonable based on based on his statement, based on gun, okay? Based on Officer Detweiler saying, absolutely, I would have shot had I seen that. We have proven more likely.
Not to mention, remember now, family, remember, this is all after he already said I was leaving. He already said, okay, cool, I done checked your information, everything is cool, I'm gonna go back to my car, go about your day. And then you still came back with this bullshit.
And not, what else though, ladies and gentlemen? His belief that he had a gun. And again, this screws up the state's theory that he made it all up after the fact. What else? Because he says, get back to Officer Detweiler. I can't see his hands. He's still got a gun. Find the gun. Find the gun. Why do you tell somebody that if you don't believe there's a gun in his hand? You don't. You don't yell gun, gun, and you don't tell someone, hey, wait a minute, get back. Now, that's not just his statement on the stand. That's Amy Detweiler's remembering and perception. And it's backed up by the body camera. You hear it, and so you get back. Don't get him until that. Those are all corroboration that Adam's belief that he had a silver revolver in his hand, ladies and gentlemen. And yes, he's mistaken about it, and that's the hard part. We're asking you as a jury, the hard thing to do when there's no weapon, that there was no weapon in hindsight. So remember we talked in voir dire, we ask you to be a clinician. It's a hard thing to find that someone made a reasonable mistake when there's no gun. If there was no anything there, okay, they got an argument. If there's nothing there, their own expert says, hindsight, he had keys in his hand. We know the keys are there. Ladies and gentlemen, the judge will tell you the objectively reasonable officer can be mistaken, even if he had a mistaken belief. As long as that mistaken belief is reasonable and under the then existent circumstances, the officer is justified in using deadly force. If an officer reasonably but mistakenly believed the individual posed a deadly threat, the officer would be justified in using deadly force. So I'm not sure what he doesn't understand or what's hiding or something like that. It's been no hiding that our client did a voluntary written statement, a voluntary interview. He testified in front of a family, in front of people, in front of 15,
Hold on now. Aaron said a key word, obfuscate. If y'all don't know what obfuscate is, I got a little clip real quick before we get it up out of here. I got a little clip for the obfuscation from Fanny Pack Willis herself in the Fanny Pack.
Obfuscate. Man, our system got hacked.
But what if the defense requested?
Well, no love, that's where the delay tactics come in. We stall. We obfuscate. We create roadblocks. By the time they get their hands on it, the trial is over and they're too tired to fight it.
But what if the defense find it anyway?
That's when we employ the damage control. We spin it, blame it on the defense, or simply deny its significance. Remember, ladies, confidence is key.
Technique 1.
Y'all go check that out. More tunes coming soon. It's been a little bit of delay, you know, fighting with the AI, but coming soon. Don't be mad at me. We gonna make it happen. The obfuscate. That was the focus. The obfuscate.
15 strangers about what he went through. And they don't believe it's reasonable. Now, there's other things that the judge will tell you, like Ms. Stevens said in the opening. The judge is going to tell you that actual possession of a weapon is not relevant, as long as the officer reasonably believed the individual possessed a weapon. The law does not require officers to wait until an individual uses harm or starts to use harm or confirm the serious threat of harm exists. There is no checklist to say, oh, I got to wait a certain amount. I got to wait to see if there's an actual serious threat. No, that's not how they're trained. That's not how they're trained. Because as a society, we don't want them to make mistakes because we know that a mistake can be deadly and tragic, just as this case is. We know that, but we put officers in impossible situations. We put that family in an impossible situation to tell them about justification, and we put you guys in a difficult situation because there is no weapon there. It was a mistake, whether or not the perceived deadly threat was reasonable, whether or not the mistake was reasonable, ladies and gentlemen. That's exactly what we have here, what the judge will read to you. So Mr. Stoughton and his creations, those are distractions. And I understand, ladies and gentlemen, it's a tough law to follow. We talk about that in voir dire. It's a tough law to follow, okay? But that's the task that you have, and we all trust that you can do it and follow the law. Moving on to the second prong of justification. Second one, remember, decision to use deadly force was reasonable, given the totality of the circumstances based on the eyes of a reasonable police officer on the scene. Now, you're going to hear that over and over again in the instructions. So I'll get right to it. Is it more likely than not that his force was reasonable? The state put up 2 witnesses that both confirmed that. The first, Amy Detweiler, how she was trained, the stuff that she goes through, the shoot, don't shoots, the train to stop the threat, actions faster than reaction, you don't have to wait. All of those we went through with both Officer Detweiler and Branford, their witnesses. And both of them said if they perceived a deadly threat, they would fire. That's their witnesses, ladies and gentlemen. I hope you believe that Mr. Branford, or Officer Branford and Detweiler were credible. How credible was Officer Detweiler when I went to show her the picture of the keys? What'd she say? She goes, I don't recognize those. Okay. She's not going to talk about it because she doesn't recognize the picture. Okay, that was our part.
Boy been on the mic the whole time. You just happen to walk away from the mic to say that bullshit? Oh, I don't recognize the keys. Nigga, that works against you. Why would you say that? Of course, that's why you walked away from the mic, huh?
That's someone who's telling the truth and who's credible. And what did she tell you, ladies and gentlemen? She told you that enough. They talk about this lack of communication. Amy Detweiler gets out, goes 10-4, meaning, no. She had seen the person walk away. Nothing's making sense. Something's weird. Bruh. What does she do? What does Amy Detweiler do at that instant? She pulls out her gun and gets it low and ready. That's based on her training and experience, ladies and gentlemen. But Seth out and have you think, oh, no, it's okay. Someone wandering around a dark garage? Oh, no, that's all right. Why did the most credible thing, Amy?
So that's what they do? They just go digging in people's dark garage? If it's dark and someone's there, we got to investigate it. What? What are you even talking about?
That what I said was, I asked her this, why didn't you shoot? Sir, we're trained if we don't see a perceived threat, we don't shoot. Why? I asked her this, why didn't you shoot? Sir, we're trained if we don't see a perceived threat, we don't shoot. What could you see? I couldn't see the right side. I asked her how she felt about the cell phone. She goes, I felt like a fool because I fell for the distraction. They're trained not to. They're trained to keep looking at different things. She goes, I felt like a fool. That's someone who's credible. That's someone who's reasonable. She didn't see the right hand. She's not going to tell you unless she's sure, ladies and gentlemen. Well, what was she sure about? She was sure that Adam Coy believed he saw a silver revolver. She didn't see the right hand. She's not going to tell you unless she's sure, ladies and gentlemen. Well, what was she sure about? She was sure that Adam Coy believed he saw a silver revolver because he announced it, gun, and he told her, don't go up there. Branford, again, on a robbery call. And I asked him, if someone presented what you believed was a silver revolver, even though on the robbery call was something else, he would shoot. That's reasonable. Those are their witnesses, ladies and gentlemen. We provided you 2 witnesses, and I'll get to the witnesses more, who went over that. These experts, ladies and gentlemen, that we presented you, train officers. Their expert trains law students, okay? They all indicate that if you perceive a deadly threat, even the government's expert says, if you perceive a deadly threat, the use is consistent, the use of deadly force in response is consistent with national policing practices. Now, the state wants you to focus on a singular thing, ladies and gentlemen. What I mean by that is they want to take everything out of context. Well, he didn't use vulgar language with you, right? Or he didn't have to do this, me and Mr. Hiller have to do that. So let's talk about all these ambiguities that Mr. Stoughton goes through. And an important thing here, ladies and gentlemen, is the timing. What time is he sent out on the run? Like 1:30. Says he gets out there in 5 or so minutes, okay? What time does he run the tag? 1:45. So he's been on the scene, we know at least probably 10 minutes. What time is it aired shots fired? It's like 2:02. So from 1:35, ladies and gentlemen, 25 minutes puts you at 2 just after, okay? That's 27 minutes that our client encountered Mr. Hill and observed things. The end was very fast, yes. But keep that in the back of your mind, the time issue here. Now, I'm going to walk you through from the time he got dispatched all the way to the use of force, okay? Is it common sense to believe that someone will answer the door or that someone will turn on a light or anything at 2 in the morning if you're waiting for them? Of course it is. So does it make sense that no one does? No. And you have to put that in your mind. And he doesn't just do it once, he does it twice, loud. Mr. Pearson doesn't tell you that in his closing. He skips right to the garage.
Bruh. Where is the crime? Where is the aggressiveness? Why did you shoot this man? Why are you spending all this time? I had to skip past a little bit, and I skipped past, and you still talking about the same damn shit. The fuck are you even doing? My bad. Let me fast forward some of this or something, because he about to frustrate me. Burn the house down. Burn it down.
Twice, ladies and gentlemen, and no matter how much he gets paid an hour, $3.20 or whatever an hour, with regards to knocking on the garage door, Mr. Stoughton watching on this door, or he gets paid an hour, $3.20 or whatever an hour, twice, ladies and gentlemen, and no matter how much he gets paid an hour, $3.20 or whatever an hour, with regards to knocking on the garage door, Mr. Stoughton watching on this door, or whether or not it's a typo. I mean, ladies and gentlemen, for real? Okay, so then what happens? He comes back. Common sense. Adam Coy being reckless at this point, doing anything? No. Common sense. Hey, what's going on? The guy goes, opens the car door, rustles around and grabs something. Officers are trained that that's an opportunity to retrieve something. They have to think in advance. They have to expect the unexpected. Is that an opportunity where someone might have grabbed a gun? Point, ladies and gentlemen. As he's approaching, got the flash set out as he's approaching. Hey, come out here, show yourself.
Let's try again. Let's fast forward a little bit more and see if he'll talk about something that matters.
Okay, he turned. Come out here, show yourself. Something's not making sense. He doesn't come out at first. And then he comes out, not fast, not slow, but they're both watching from different angles. And what does Adam tell you? I see him get closer to the car. It's a tight confines when you look in there. I see him turn towards us. What's that? That's a cue. Now, it may not be the part on the video that's there, but that's what he sees. And guess who else sees it? Amy Detweiler. She's coming up from straight ahead. And she says, yeah, I'm walking up straight ahead, and then I see the thing, but I see him turn. I can't see his right side. She has more of a straight angle at him than that. So in order for their theory to be correct, that he made this up after the fact, that means Amy Detweiler's in on this conspiracy. That means Amy Detweiler should be charged with accomplice to murder. And she's not, because it's a ridiculous theory. Because if you yell gun, gun, then Amy Detweiler's got to be in on it. Gun, gun, gun. If you say, hey, he's bladed this way and I can't see him, that means Amy Detweiler has to say, oh, I was on this side, but I couldn't see his right side. That means she's in on it. And the worst thing, ladies and gentlemen, would you ever turn your body camera on if you lied about this from the go? No. The government says Adam Coy, a Marine, or excuse me, an Army, 5 years honorable discharge, giving service to his country, a family person who has given his life to this community, made it up and lied, and somehow got Amy Detweiler in on it too. That's what has to happen if you believe their theory of why he shot, that he created the lie after the fact.
That would be the right front, the right left, excuse me, the right left side.
What did Jim Scanlon say about the garage? There's a guy with common sense, right? Hey, do you want someone to investigate if you found out that your garage door was open and it was 2 in the morning and it was dark and someone was in there? Of course you all would. That's what we ask of the officers to do. But somehow that's reckless to the government. Somehow that's not doing your job. I don't care what's going on out there.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop.
He just could see the bubbles. Case over. They proved their burden beyond a reasonable doubt. Just like that, ladies and gentlemen, just because of that credibility. Wow. Now, what was the second one? The windowsill. In his written statement and his statement, I guess, to the BCI agents, he said, yeah, he put the phone out like this, and he put the left elbow on the windowsill, and then he made an X. Okay. Well, geez, in court, he said, okay, well, I saw the left hand go down here and make an X. Where would your left elbow be, ladies and gentlemen? On the windowsill. He was right that he rolled it down. He was consistent about that. He was consistent about the X, consistent about showing, consistent about what he said, but somehow that's a huge difference. Now, I got to ask Mr. Scanlon those differences. Any of those two differences, would that change your opinion in any way, shape, or form regarding the use of force? Absolutely not. Mr. Scanlon looked at me like I had 3 heads or something. He's like, what are you talking about? That's desperate, ladies and gentlemen. That's desperate. Now, we did something in voir dire, ladies and gentlemen, where I showed you, life and death situation. Count how many times the person in the white t-shirts passed the ball. Most of you had the wrong numbers. Half of you didn't see the throw. Okay? Are you lying about that? No, absolutely not. Because the human eye trains on different things.
Denied.
Body-worn cameras don't interpret what the human eye sees. They don't interpret what the human eye perceives.
Bruh.
Now, I'm going to put you in a life and death situation now. For 27 minutes, the time that Adam Coy was there today, I want you to write a 10-page statement. I want you to I want you to be interviewed for hours upon hours. I defy any of you to only have 2 minor inconsistencies.
Well, isn't this a nice surprise?
10 pages.
Submissive enough.
We about to hit him with the wrap it up button. Wrap it up, B. Wrap it up. We done with all that bullshit. Wrap it up, B. We ain't got enough time for all that. Let's move on, man. You bullshitting. We might come back if necessary. I'll come back from where I left off, but wrap that shit up, man. We out of here with that one. Let's keep it rolling. Appreciate y'all, family.
Bruh.
Wrap it up, B. Wrap it up.
It was a closing argument here about perception. He talked about it in his closing argument, defense counsel. But I look at this a little bit different. I look at this a little bit differently. This is how I look at it. Adam Coy shooting an unarmed man who was simply following his orders. That's what this gorilla represents to me. And all this other stuff, it's just noise. Blading. Keys in the hand. Cell phone up. Showing text messages without being asked about them. Not submissive enough. That's how I see this case, as it relates to that. Mr. Hill being shot in this garage.
Can I pet that dog?
No.
Can I pet that dog?
You can't.
No. Can I pet that dog?
No, he's
Can I
sleeping.
pet that dog?
By Officer Coy. He's the gorilla. All this other stuff is just to distract you from what really happened. If Mr. Coy is not responsible for situations like this, then we got to be training our citizens to not listen and follow police orders. That's where we're at. It's exactly where we're at. Defense counsel wants you to believe that, show yourself and showing your hands means the same thing. It means the same thing, it's no big deal. Those things are huge. Those things are huge, especially when they result in the loss of life. How is Mr. Hill supposed to know that the magic words being used were raise both hands without anything in them, or just show yourself? We're taught from the day we start driving, sometimes before that, do what the cops tell you to do. Do what they tell you to do, and you can survive that encounter. That's not what happened here. Mr. Hill did exactly what he was told. And it may be loose language, lazy language on behalf of the defendant to just tell him to show himself. It may not matter to him. Show yourself, show your hands, whatever.
Is not the evidence.
You know who it mattered to?
What?
It mattered to Mr. Hill. That's who it mattered to. Now, I'm not saying that Detweiler's in on it. I'm not saying that she didn't testify truthfully. She testified that if she saw a deadly threat, she would react, and that she would shoot to stop the threat. Great. We want all of our police officers to do that. Key word, threat. There was no threat here. She didn't say, Mr. Collins didn't hand her a set of keys and say, if you see this, are you going to shoot? Would you shoot? He didn't say that. He said if you saw a deadly threat. And she said yes. She didn't shoot that night because she didn't see a deadly threat. And the circumstances surrounding it doesn't support thinking that a man in a garage holding car keys after exiting a car would be holding a revolver. You heard Professor Stout say this. He said, yeah, police officers get ambushed. Yeah, it does happen. But you can't use that as the industry standard. You can't use that as the norm. You can't use that just because it happens.
I'm talking, make me. It's my time. It's my time.
It's contextual. Context matters. And it mattered in this circumstance. Hindsight is 20/20. We're not supposed to be looking at hindsight. But you know who is looking at hindsight? The defendant. He's looking at hindsight.
Why do you bother to bring your ass out to my lecture?
I'm not disputing the fact that he told Amy Detweiler, don't go there, we don't know where his hands are, something to that effect. I'm not disputing the fact that he patted him down. I'm not disputing that.
Monkey shit.
That's why there was so much questioning about whether mistakes must be reasonable, or is it okay for an officer to just make a mistake? All three experts confirmed that if your officer is going to make a mistake, especially if it's deadly, it must be reasonable. Officers don't just get to walk because they make mistakes. But yes, they make mistakes, but if they're reasonable,
¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas?
That's when they're not responsible for the things they do. Here, this was not reasonable. I'm not saying he had a conversation with Detweiler about it. I'm saying after he killed Andre Hill, discovered that there was no weapon there, that all at most this man held a set of car keys, he has to figure it out. He has to find what he missed, according to his own words. And then he goes back and he uses his 20/20 hindsight to figure out, what can I point to that's suspicious? Oh yeah, he did talk to me when I didn't ask him. How is that suspicious? Mr. Hill was just being nice. And I'd be willing to say that if Mr. Hill hadn't talked to him first, Mr. Coy would say, he didn't want to talk to me. He didn't want to talk to me. I found that suspicious. He didn't show me his cell phone that he was clearly operating. I found that suspicious. It's ridiculous to think that looking at Mr. Hill's actions, according to Mr. Coy, that Mr. Hill may be involved in a burglary. First of all, I found it interesting that the defendant wanted to walk away or walk back the fact that he said that he thought Mr. Hill was involved in a burglary. But we'll set that aside. I think it's a ridiculous proposition. Like burglars go knock on doors? You got the police outside, and you're gonna go knock on a door? That's not how burglars act. That's how someone who's waiting on someone acts. Oh, he was a lookout. He was waiting for someone inside. Oh yeah, you ever heard the phrase, no honor amongst thieves? If he was really a burglar, he would have hightailed it out of there. He was communicating with someone on his phone. He showed that to the defendant. Wouldn't he have texted the person in the house and said, hey man, I had to bail, the cops are here. You might want to leave. He didn't, he stayed there. If I'm shoplifting at Target and the police show up, guess what I'm gonna stop doing? I'm gonna stop shoplifting. And it would be clear that if this defendant thought that Mr. Hill was up to no good, he wouldn't have been doing the things that he was doing. It's more conducive to him waiting on someone than him committing a crime. Your Honor, can I get my computer here?
Yes.
Thank you. What would a reasonable officer do if he suspected criminal activity? Ask the person's name. We're supposed to believe that Mr. Coy felt that Mr. Hill's actions were so suspicious, he didn't even ask him for his name. He ran the plates and they came back. He didn't know if that was Mr. Hill's plates or not. How? Because he didn't even ask him his name. That is one of the lowest levels of law enforcement, is asking someone for their name. He didn't even do that. He didn't ask Mr. Hill for his identification. Hey man, can I get your ID? The neighbor out here that's kind of concerned. I just want to make sure everything's good. Can I get your ID? He didn't ask that. He didn't do that. Why? Because he didn't think it was a big deal. Because he did not suspect Mr. Hill of committing any crimes whatsoever. Knock on the door to see who was present. He could have went up to 1062 Oberlin, banged on the door. It's a guy who's in a silver car. He says he's waiting on somebody in the house. Are you good? We good? That's all he had to do. Or bang on the door. The garage is open. You're aware that this guy's out here? But no, he didn't do that. Why? Because he had no concern. He could have ordered Hill to come down. He said something to him as Mr. Hill walked up the driveway. Again, the police are outside. Now we have two cruisers, and a man who he suspects is committing a violent crime, an aggravated felony, is just going to go walk up to the house when he has a car there that he could leave. It doesn't make sense. The story is made up to make Mr. Hill look like a potentially violent criminal so he can justify his reasons for shooting an unarmed man. Not that this is a big conspiracy, but the fact that he made a mistake.
Right, hold on. That's a big fact right there. Like, hold on. If you was doing anything illegal, hold on. Think about it. The cop already came and talked to you. He already came and cleared you and said, okay, everything is good. It's cool. I'm going to go back to my car and everything is good. Why would you then go and try to break in a house when you see the cop sitting right there? It don't make no fucking sense. Why would you try to do that shit when you see him sitting there? It's obviously a lie. It's obviously a lie. Like, that don't even make no sense. If anything, you would have just left. Oh, you said I'm good to go? Well, fuck it, I'll leave then. Why would I sit there and still try to break into a house? That don't make no sense.
The truth is that you are a liar.
And it wasn't reasonable. That's the cover-up, that he's trying to convince everyone that his mistake was reasonable. Because if Mr. Hill, if he had seen as you see him, as the evidence shows, he wasn't doing anything wrong. So then the defendant has a problem because he has killed a man who was in a place where he had the legal right to be without any weapon. He can't explain that away without talking about these things that really didn't happen. He could use the PA system. Oh, we don't. We don't use the PA system for that. We don't use well, he didn't hear you. He didn't hear you. So you could yell louder. You could shine the flashlight on him and yell louder. You could use the PA system. Those are perfectly easy tools that you could use if you feel like there's a potential violent criminal not obeying your orders. You could ask to see Mr. Hill's hands as he's exiting the garage. Hey man, come here, let me see your hands. They act like that defense counsel acts as if that is prohibited language to ever tell somebody to see their hands. They act like that is not vernacular that police officers use, that he didn't have time. He did, but the expert did say he had time to say, something's not adding up, come here. But he didn't have time to say, show me your hands, dude, come here. He couldn't have said that? He absolutely could have. But the problem is that he did not view Hill as a threat, even at that time. Amy Detweiler said she had her gun out at the low ready. Why? Because she's approaching a dark garage. Nothing more than that. She's just approaching a dark garage, so she has her gun at low ready. The defendant, he claims he didn't have his gun out at all. Again, he had no reason to think that Hill was going to do anything to him. And so it goes from nothing to deadly force without proper evaluation. And he's got to make up a cover for that. So then he uses 20/20 hindsight, he works his way backwards and thinks about all these interactions he had with Hill to justify that. Tell your partner, I think he could be dangerous, he could have said. As they're walking up, hey, this guy could be dangerous. I talked to him earlier, he may have a weapon. I talked to him earlier, they may be doing a burg. I talked to him earlier, there could be he could be a lookout for somebody doing something crazy in the house. You mean to tell me he's gonna let his partner that he's worked with for her entire career walk into an aggravated felony situation and not tell her about it if he actually had concerns? That's hogwash. He didn't have concerns. Tell my partner, watch my six, watch my back. I think he's casing the joint. Instead of doing any of that, what did he do? He shot and killed Andre Hill. He asked for water. Says, I gotta find what I missed. That's what he did. Says, I gotta find what I missed. That's what he did.
Again, right before going and grabbing his pills after the other officer said, oh, you gotta find what you missed? Okay, I need to go to my car and put some stuff in my trunk. Go ahead and grab your pills and shit so we can help you get rid of them. Fuck out of here, man. Man. And you knowing this, man.
You don't need a use of force expert or an ex-cop or anything like that to tell you that if an individual police officer is with another cop, he's going to warn them about a dangerous situation and say something other than it's weird. He didn't even say it was suspicious. You've heard all testimony from law enforcement people that said suspicious has a special connotation, meaning that you could interact with somebody a little bit more than just being present. He didn't even say that. It's not called reasonable weirdness. It's called reasonable suspicion. He didn't even say that. At best, Hill's actions were weird. They've done thousands of runs. Thousands of runs. He should know better, know how to operate and come in contact with somebody who has something silver in their hands after they just left a car.
Hey, real quick, hey TSC, I let your comments through. A couple of them YouTube was trying to flag. I let them through. You know what's crazy is that they asked me before I even go live, is this made for kids? It's very clear that my content is not made for kids. I don't make any content for kids. So why would you flag me for any type of profanity or any of that shit? Because obviously that's not an issue here. But it's for those sensitive, so they can just use that to be like, oh, if we don't like you or if we don't want to promote your channel, we can say you cuss. But then you got cussing channels that's making millions of dollars though. But it's just another thing. Just like what we watching in these court systems, YouTube be doing the same shit. Let me hurry up and get off of here. I think I'm feeling myself. It's about time to wrap it up.
And I love how defense counsel kind of meshes things. We started off with Coy staying on the stand. I saw something metal in his hand, right? That's the most he said. I saw something metal in his hand. He didn't say leveling. He didn't say I saw the glint of steel coming up at me. He didn't say that. He said he saw steel in his hand. Defense counsel gets up here and says, yeah, Mr. Hill started to raise his hand. And then we get to pointing directly at him. Come on. Those are all very, very different things. Mr. Coy on the stand said that Mr. Hill had something in his hand that looked to be metal. Could have been a pack of cigarettes, could have been a lighter, could have been car keys, could have been 1,000 other things. And again, I can't get away from the fact that if the defendant thought it was so important, all he had to do was say it. Even if you think he's a violent felon, even if you think that he's got all heck is breaking loose, you don't get to kill him.
What's crazy though about that, my bad to interrupt, but it wasn't even like no crazy offensive stuff. Like it wasn't no against nobody specific or nothing like that. It wasn't even offensive like that. There was no reason for it to be blocked. Like they act like you can't say one cuss word. You can't say ass. And they was doing the same thing to Chan, my black is golden. They was doing the same thing to Chan, my black is golden. And she was paying for a comment and they was still blocking the comment just because she said ass. Like stop playing. Like what is this? What is this? This is not a commercial. This is pay-per-view type shit. Stop playing. If they don't want to watch it, they don't watch it. If you a child and you can't hear cuss language, then this is not the channel for you. That's why it's only this many people watching, because I'm gonna keep it real. We gonna keep it real, and ain't no like keep it real hood shit. It's just like we not covering up and trying to bend into this box just because that's what you want to promote for yourself. But that's not freedom of speech. It's freedom of speech. So let's do that. Let's wrap this up, man. Appreciate you. Shout out to TSC. I appreciate you, family. And shout out to Chamo Black is Golden. They be blocking her comments too.
For it. If they're following your orders, maybe you think, okay, he's being kind of weird. Well, I tell him to come here. He's coming here. He's following orders. He's beginning to comply. And I don't... Partial compliance? Partial compliance? Are you kidding me? Partial compliance. He said, come here. The man, Mr. Hill, didn't yell at him, didn't curse at him. He started to go to where he was called. And he raised his hand with this cell phone, maybe to shine light so he wouldn't trip, maybe to say, hey, I know people sometimes get shot with phones in their hands. Here's my phone so you don't, get weird here. Defense counsel says he has keys in his hands, and the defendant says he saw something metal and he gets shot for it. Their own expert says, I asked him, what could be something that's not natural, that is natural human movement, that someone can do that wouldn't be considered acute? He had a hard time with that question. And his answer was, well, if Mr. Hill would have came out of the garage with his hands, both of his hands up, okay? So, Mr. Hill's in that garage, he's ordered to come out. What's he gonna do, this? He's a dead man. He's a dead man. Because this defendant is gonna say, well, he raised his arm at me and I saw something leveled at me that was metal. So Mr. Hill just showed the light lit phone. Also, maybe he was saying, look, I've already showed you this. I'm telling you, hey, look, communicating with somebody in the house. Defense counsel wants to make deal about Professor Stoughton never saying the words Graham versus Connor. Graham versus Connor, Graham versus Connor. The law of this case will be given to you by the court in the jury instructions that he's going to read to you when I sit down. Nowhere in there are you going to hear the words or see the words Graham v. Connor. You're not going to do it. It's not in there. Detweiler, defense counsel says Detweiler talked about how she didn't fall for the distraction. What distraction? The man had car keys. He wasn't distracting anybody. Was he wanting for her to not see the keys in his hand? He was showing up his cell phone to say what he was there for.
The defendant had about a month to write his written statement and talk to investigators. About a month. He can come up, think about all of these things and get them all nice and tight. He had about a month before he said anything to anybody about a potential burglary situation happening in that house. Path of travel of the bullets. Defense counsel wants to say that
because he was shot on his side, that it must have been bladed for Officer Coy to have access to that side to shoot him. Well, we don't know that the order of bullets. He was shot 4 times, some in the leg area and the body area. So you can see it on video, which I'm going to show here in a minute. If he gets shot or shot at, he could move. That's what the pathologist testified to. You can see it for yourself that there's no blading. He wants to make a big deal about Stoughton training law students. Well, Professor Stoughton trains law students, but he also trains police chiefs, police executives as well, law enforcement officers. Defendant's actions aren't consistent with a reasonable officer. And you've had experts testify about certain things. Well, the beauty about this is that it's your decision. You can believe any, part, all, or none of the experts' testimony. It is your decision to decide what this conduct is. And again, ladies and gentlemen, I keep going back to just because it is a threat does not mean that it is a legitimate threat. It does not mean that it is a reasonable use of force because someone is scared, because someone made a mistake. You can believe all you want that the defendant made a mistake, but that mistake has to be reasonable. And under these circumstances, it is not reasonable. I'm afraid of heights. I didn't fly my first airplane until I was 18. And state police officers and their mistakes, but when it's not reasonable, they must be held accountable. Remorse does not equal threat. Let's say if a witness saw a crime and they waited 30 days to give the details to police, wouldn't you have some concerns about the truthfulness of that statement? That's what happened here. Can I get my computer again, Your Honor?
You have it.
In his lap.
Well, isn't this
Andre Hill's arm was blocking his lap. During trial, he said his left arm was on the window sill and his left hand was on his right knee, covering up his lap. During the verbal interview with BCI, he says Mr. Hill put his left arm on the window here, his left arm onto the window sill. Why is that important? Why do we care? We care because when someone's not telling the truth, it's hard to be consistent. It's hard to remember your lies and the things that you told before. Why would he make that up? Well, again, he said on the stand that his left arm was covering his lap area. Oh, because that would make him a little bit more suspicious. That's why that matters. That's why it matters. That's why we get that story that we got. Besides the fact of physical impossibility, I mean, he must have the longest arms in the world to be in an SUV and have his arm on his right knee. His arm was on the windowsill, maybe displaying both hands so nothing would happen to him. That's why it matters. He showed me text bubbles. That's all I could really see, sir. I couldn't read the text. That's what he said on the stand. And then he got into a back and forth with me because his written statement said he showed me his phone screen that had a text message on it and said, "I'll be right out," or something to that effect. My question was, the interviewer's question was, in his verbal interview, did you see the text messages? His answer, he held it up, and I seen something on there that said, "Be out in a sec," or "in a sec." Why does that matter? Because he's trying to make Mr. Hill look worse than what he really was doing. Because if he saw a text message, then that would justify why Mr. Hill was there. If he says Mr. Hill just told him that, then he could say, well, he could just be lying to me. I don't have to believe his words. Walked up the front of the driveway with Officer Detweiler. Now I'm going to show you this in a second, this video. But Your Honor,
Real quick, family, we almost up out of here. We got a little bit more to go. We're going to wrap up. I'm going to let him go ahead and finish. We're going to play the rest of this testimony, not testimony, the rest of his closing arguments. And then I got a little small clip, and we up out of here. So maybe about 15 more minutes or so. Let me see. Where's this at? We at 10. So I don't know. Yeah, maybe I'll say about 15 more minutes or so. Something like that. We'll be up out of here. Appreciate y'all, family. Let me start checking for lives, man. I need to start doing that. The other day, Kat was live. I was mad I didn't pass it over to her. That was kind of shady, but I didn't know. But anyway, we almost about here. Appreciate y'all. Hit the like, hit the subscribe, tap in, share with a friend. Let's go.
Could I get here for a second? I had him look at A48, and he says that Mr. Hill was back here crouched down. Said he was back there crouched down. Remember that? Said he could see the cell phone light because it was crouched down back in this area. That's important when we talk about his trajectory of his path of travel. Because according to what he said on the stand, he said he went right up the driveway. And if you go up the driveway, yeah, you would be able to see all the way back there. But when we look at his body-worn camera, which I'm going to play in a second, you get this angle. The car is blocking him from seeing Andre Hill crouched down and seeing his cell phone. Why is that important? Because he's trying to make Andre Hill look like a suspicious, aggravated felon. But it just doesn't add up. Thank you. My computer again, please. Look at the lights. Where he sees Amy. Out, they have a short conversation, and he goes up the driveway.
No, I actually don't see nobody. And shout out to Kat, because you know when she be passing them redirects, you know you gotta actually go to a certain spot. You gotta go to redirect, go find that, and then you gotta type in each person's name. So when she be looking for those lives, she gotta type in each person's name. Man, show her some love for that. Shout out to Kat. Drop some KSPN just for that. But we almost about to here.
He goes to the neighbor's house.
I say that to say, I look for some people. I ain't seen nobody else. If y'all got somebody y'all would like to go to after, let me know. Other than that, we almost up out of here.
Mr. Coy, and he's walking up the driveway. There's no way he can see back in the corner of that garage. There's no way. The car's in the way. He can't see back there. I'll continue playing. Oh, sorry. There's no way he can see someone crouched down back there.
Why do they be putting this bullshit? That is not the real, that's not the image. Why would y'all show it like this? That's insane. There's no way he can see. Of course they can't, because you didn't change the whole video. That's not how the video looks. We didn't play the video plenty of times. Why would you play this bullshit? You can't see nobody. Of course not. With this man, he needs to go to jail. You need to lock him up for playing this damn video. That's fucking malicious, not even malicious prosecution. I don't know. That's the other side, but something, I don't know. Lock his ass up.
Not only is there no light, but also that angle. There's no way you'd be able to see Andre Hill crouched down back there by his path of travel. Again, these aren't my words. I'm not making this up. He's making it up. You can see from the video. I questioned at trial, and did you see Mr. Hill? You said you saw a glimmer of light in the garage. Are you able to show from this photograph, State's Exhibit A48? Yeah, back over here. He was back over there, crouched down. Does not show that he is blading as he's walking out of the garage. It does not show that he is blading. My apologies, Your Honor. Could I get the lights dimmed again? Thank you. I'll fast forward. You'll have State's Exhibit H, which is what this is. Mr. Hill, walking as a normal person walks. I'll show it again. He is walking as a normal person walks toward a flashlight that is being shined in his eye.
Why would you show that video like that? Anybody who's been watching this trial, I mean, we've done, this is like episode number 4 or 5, I don't know. It's enough of them. This is the last one. But we got plenty of them before that shows the clear video. Why would y'all show this altered ass video? Why would y'all alter it like that's how it looks when you know that's not how it looked? You did that. Why would you do that? That automatically you guilty. What the fuck?
Clearly not blading. He's not in a boxer stance. He's just walking. Thank you, Your Honor. I'm done with the lights. State need not prove motive. We don't have to prove why Coy did what he did. We showed that he did it. We proved that he did it.
Oh, wait a minute. Oh, shit. Hold on. Let me pop my face up. Let me show my face. YouTube they get mad when you don't show your face. Let me pop my face up for this one. Hold on. I almost thought that was the prosecution. I forgot that was the fucking defense. I mean, that is the prosecution. You're making me think a lot. I thought you was working with the other side. How did you alter the video? This is your video? I thought that was their side. So if you altered it, that make it look bad on your side. Don't do that. My bad, man. Shit. Damn, my bad. That don't even count. That look bad on the prosecution side. That don't look bad on the cop side because they altered it. I thought the cop and them altered it.
Then they have the burden to prove that he was justified in doing it. It would be a death sentence for him moments sooner if we were to follow the advice of Mr. Scanlon of just raising both hands up in the air. When Mr. Hill went in that garage, it became his coffin. There was no way he could get out of there alive with Officer Coy on the scene. There was no way. There's nothing that he could have done. Anything he would consider a threat. Not a reasonable threat. Not a threat from a reasonable officer, but him. No one has said and given Coy justification for shooting a man who was simply following his own orders. You've heard from defense counsel a lot in this trial, in their closing arguments. They don't want you to believe your own eyes. That's video, the photographs, the impossibility of some of Coy's statements. They don't want you to believe your own eyes. I'm asking you to do just that. Believe your own eyes. Because if you don't believe your own eyes, If you ignore common sense, then you just might find him not guilty. But I know you have common sense. I know you trust your own eyes. And so when you go back into that jury room, take a look at this video. I didn't want to play it for you here. Take a look at it when you feel you can. And I'm going to ask you to do 3 things. Believe your own eyes. Don't check their common sense at the door. And follow the law. If you do just those simple things, I believe you'll come to the decision that the defendant is guilty, that they have not proven the burden by preponderance. I thank you for your time.
Thank you, Mr. Pearson. Okay, ladies and gentlemen, at this time, I am going to provide you the instructions of law in this matter. All right, Mrs. Harper. Of this case, instructions to law. The portion of the instruction considered reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any facts the court requires you to accept as true.
Assistant District.
Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which the witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experiences of humankind. To infer
show that the use of deadly force was reasonable, and as a result, there will be no criminal charges filed in this matter. And this matter, in my opinion, is a justifiable homicide.
Was killed after
the body camera video of a deadly shooting from earlier this summer, that shooting deemed justified by the prosecutor.
Yeah, the camera footage, but we of course are not showing you that. 5 of them struck Jackson, killing him. The Macomb County prosecutor calling this all justified.
And obey the command of the officer.
This is after he ruled the deadly shooting a justified homicide. Austin, what did DA Carr say led to the incident?
They saw strictly from when the struggle ensued, when the body cam turned on. And based on that footage that was depicted in there and based on the law, that because of that, we deem that shooting a justifiable shooting.
Carr says the Winnebago County prosecutor says an officer was justified when he shot a man who later died. This case from Lake.
The case is closed as yesterday the Attorney General cleared the sergeant of any charges. Tom Amato shows us
30 days. All were deemed justified. Nearly a year ago, and was just one of 3 officer-involved shootings that happened within a span of 30 days. All were deemed justified. Officer use of force cases are never easy, but the legal standard was met in this case.
We proceed with an internal review, see if there's anything that we can learn from the incident, anything that we can see as lessons that we can take away for training.
Tonight, new body cam footage released in 3 JSO shootings. These are among the 14 shootings the state attorney's office recently found to be justified. Tonight on Your Side's Jocelyn Howard breaks down what these new videos show.
Leroy Edwards Jr., Keon Wilkes, and Timothy Lagonia. 3 cases among 14 police shootings the state attorney's office recently found to be justified. Hands out of your pocket! 4 attempted murder charges. We're still waiting on body camera footage from several other shootings that prosecutors deemed justified.
Shouting its investigation into a traffic stop in Holly Springs where the officer and suspect were both killed.
The agency finding the officer did nothing wrong, and for the first time it's releasing video from the confrontation.
Attorney stating Officer Joe Burson's actions were justified.
Cherokee County DA Shannon Wallace wrote, Burson's actions were justified under Georgia law, and if Dose was alive, this office would have pursued a prosecution against him for murder as well as other charges.
And then
we can't confirm that right now. But
were 2 found dead?
Yes.
Was there 6 shots, or do we know how many shots?
We don't know.
Found dead that were family members, is that correct? And then
we can't confirm that right now.
It could be proven otherwise in a court of law. He obviously appeared to have a gun. He was not in any way indicating to police that he did not have a gun. He wasn't shaking his head or in no way indicated he didn't have a gun.
Attempted murder after getting into a shootout with police last month, and a Davenport police officer justified for using potential lethal force. Investigators say
calling a deadly shooting from July justified. District Attorney Sim Gale presenting the findings today and reviewing the body cam.
3 shots were fired.
Shots fired.
I think everybody was trying to do.
District Attorney's Office has ruled an officer-involved shooting in Albuquerque last year was justified. 3 people broke into the Catholic Center, tied up. Officer Mario Perez fired back, killing him. The DA's office decided the shooting was justified. Up until January, a special grand jury made that decision, but district court judges changed the process.
Citizens that don't have a dog in the fight, so to speak, review our decision. They could disagree. They might see something that we didn't see because they're more objective. That, I thought, was really nice.
Justified a deadly shooting involving police, and they announced their result of the investigation into the death of 19-year-old Christian Hall, who was
2 people dead and officers on leave. It's been months since a very public police-involved shooting.
It's decision day for whether 4 officers should be charged or cleared for their actions, and along with it, some telling video of how it all played out. Our big surveillance video that captured every moment of this dangerous and deadly exchange of gunfire and what it means for the case. We have 2 reports for you on today's ruling.
Have 2 families who are still grieving and 4 officers who have to live with knowing they took 2 lives. Surveillance video from a 7-Eleven on Lynn Haven Parkway shows a gunfight between police and a very dangerous suspect, Angelo Perry.
It was Mr. Perry who chose to change the circumstances that night when he opened fire on the police.
Police from a confidential informant.
At that point in time, he informed them that a Virginia Beach resident was the subject of a
car. They say he was on the way to a potential victim's home. At some point, officers thought Perry figured out who was behind him, so they decided to stop him at the 7-Eleven.
They identified themselves as law enforcement by yelling, "Police, show me your hands," repeatedly as they approached Perry.
The officers then...
They identified themselves? Look, they pulled him over? Hold on, I don't see no sirens. I don't see no lights. How do we know you police? This look like a robbery. This look like a stick-up. What the fuck is you talking about? Oh, we decided to pull them over. That don't look like no pull over. It looked like he decided to stop and see who the fuck was following them.
Then saw the passenger side glass explode and noticed a gun in Perry's hand. He was firing at them, so they fired back.
Of the officers.
Perry got off 4 shots. He had a handgun and a rifle. 4 officers returned 30 rounds, hitting Perry 15 to 20 times in Kager 10. They both died at the scene.
All were aiming their fire at Mr. Perry. None of the officers targeted Ms. Kager.
A justified homicide. That's what the Washington County DA is now saying about a deadly police-involved shooting there in May. KDKA's Bryant Reed has the new details.
Shots ensued. 1 suspect died, another was arrested, and a trooper was placed on administrative duties pending an investigation. The Washington County DA, Jason Walsh, now says that investigation is over and outlined the details for us. He says it all started when a trooper recognized his hands. He didn't comply and instead reached for a gun under the passenger seat to the chest and neck and pronounced dead at the scene.
The totality of the circumstances show that the use of deadly force was reasonable, and as a result, there will be no criminal charges filed in this matter. And this matter, in my opinion, is a justifiable homicide.
Today, a Marion County grand jury.
A justifiable homicide, as you see. And yeah, y'all can go to my channel if you want to see the rest of that. Views is super low, but you already know why. They don't want to promote that type of shit. And also, you know, things been changing. My algorithm been changing. Some of my favorites ain't here, so you know what I'm saying? It adjusts my algorithm, but all is well. Before we get out of here, we got one more clip, and I appreciate y'all all for being here. I definitely got to go because I'm stuttering on my words. I think that thing keeping in. No, I'm just playing, but let's get up out of here.
Mr. Coy is dying. He will die in prison. There's no win here. There's no silver lining, right? Mr. Hill's dead and Mr. Coy's dying. The whole entire situation was an absolute tragedy.
In the courtroom Monday was Amy Detweiler. She was with Coy the night of the shooting and testified in this trial, telling the jury there was no doubt in her mind Coy believed Hill had a weapon.
Unfortunately, the jurors only get to know Adam through his testimony. They don't get to patrol the streets with Adam. They don't get to know the type of officer Adam is. Through his testimony, they don't get to patrol the streets with Adam. They don't get to know the type of officer Adam is. So that's a difficult thing.
We shouldn't be giving people special treatment. And I've been practicing criminal law for a long time. Individuals who usually get convicted of this type of crime, bond is revoked. Individuals usually get convicted of this type of crime, bond is revoked. So I just want to maintain equality.
Remember, he said that because they gave him bond. He made that $1 million bond. And he was still found guilty. You bitch, you.
December 22nd, 2020. Central Ohio still reeling from the death of Casey Goodson, an unarmed man shot by a deputy. We learned of the shooting that killed Andre Hill.
I am deeply saddened, frustrated, angry, demanding answers of what happened in our...
Aaron, if I don't know if you still here, but here you go right here. This is what Aaron was talking about 2 weeks before. They just shot somebody else just prior to that. And that's not the only one. Remember, this Ohio. That's also where Ryan Hinton happened at.
Community.
December 22nd, 2020. Central Ohio still reeling from the death of Casey Goodson, an unarmed man shot by a deputy. We learned of the shooting that killed Andre Hill.
I am deeply saddened, frustrated, angry, demanding answers of what happened in our community earlier this morning.
CPD commanders immediately took Adam Coy's badge and gun. 5 days later, he would be fired. A month later, Columbus City Council takes action, passing Andre's Law with new directives for the use of body cameras by Columbus police.
This as their acknowledgement that there are problems that need to be fixed.
In May of 2021, Columbus City Council approved a $10 million settlement for Hill's family, the largest in the city's history.
There are problems that need to be fixed.
In May of 2021, Columbus City Council approved a $10 million settlement for Hill's family, the largest in the city's history.
There are problems that need to be fixed.
In May of 2021, Columbus City Council approved a $10 million settlement for Hill's family, the largest in the city's history.
1. Therefore, the sentence of the court is the following. As to count 1, there is a sentence of 15 years to life to be served at the Ohio Department of Rehabilitation and Corrections. Fine and court cost are waived. Record does reflect 274 days of jail time credit.
Shout out to Aaron Adventuring. Appreciate you, family. Shout out to TSC. Appreciate you, family. Shout out to No One. Appreciate you, family. Shout out to Chan My Black is Golden. Appreciate you, family. Let me see. Shout out to Aaron. Shout out to No One. Shout out to TSC. Let me see. That look like everybody up in here. That's all that's been chat. Oh, Joni Ford was in here. Shout out to Joni Ford. And shout out to our stream sponsors as always. Chan My Black is Golden. And I believe TSC, but let me make sure. Shout out to our stream sponsors. Much love, much love.
The absence of evidence is not the evidence of absence.
What?
Either way, I appreciate you all. Every like, every subscribe, everything y'all do is all much appreciated. Much love. I think that was a good one. I hope y'all enjoyed yourself. Until next time, stay fresh and stay blessed. Peace out. Rock Solid TV, I see you, family. TSC.
Metaphysical reactions. I am the flesh. I am the God.
Have a good night. Have a good night. Have a motherfucking good ass night.
I see you, fam. Throwing slime corns when I watch the trial. Leos be capping. Chatting action. Come and tap in the most interactive. I am the flesh.
Stay tuned. We got a bonus.
Wanna talk about it, hit the link right here. Slide coins up, got 100 bands. Mars eyes, watch how the check. And the band made love do a bomber head. 2 bands do a dance like check. I'ma keep going till I'm motherfucking tired. You what? I'm motherfucking tired. Slide real side, could we rain down game? Like, what you mean? Just watch the rise. Watch the rise. Watch the rise. I am the flesh. I am the God. I am the flesh. I am the God. Flesh of the gods. I see one. 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 I am the flesh. I am the God. I am the flesh. I am the God.
Hold on, my bad. I had the bonus ready, but it ain't working. They fucking with your boy. Hold on, let me see. We still can do it. Hold on, let me see. We still can make it happen. Give me a second. Give me a second. I don't want to give you no broken promises. Hold on, we still got something for you. Hold on. I would just close it, but I did say we got a bonus, so shit. It didn't work like I wanted to, but we gonna make it happen. Just give me a second. Give me a second. Shout out to Rock Solid TV. Shout out to No One. Shit. Alright, never mind. Shout out to Rock Solid TV. This shit ain't working right. Yeah. Anyway, we do got that coming up soon. So just stay tuned, stay fresh, and stay blessed. I see you know. Hey, we got it. I tried to pop it up, but man, this shit just ain't working right. I can do it, but it's gonna take longer than necessary. And other than that, I appreciate y'all, man. We get to it. Just know we gotta come in. Let's say this Saturday. I would say tomorrow, but I still gotta record this song too, cause we got a new song dropping too. So let's say Saturday. We make it official, so I don't be over here playing with y'all.
Evidence is not the evidence. The absence.
What?
Saturday. My bad. Saturday. Much love. We out, family. Until next time. Again, stay fresh and stay blessed. Peace out.